Wait, please. Item number 29, my lord, motion matter, that eviction matter, my lord. Certain subsequent developments had taken place yesterday. You want to bring it on record, my lord?
That is your lordship. I beg to mention for listing of an admission matter, my lord, next Monday, my lord.
What is the subject matter?
Matter is relating to freezer of my bank accounts, which is my business account.
That will, that you make a mention on Thursday. So far relating to those matters, because that bench will have an own schedule, just we are maintaining. So you make a mention as per the.
Hello.
May I please, your lordship, I beg to mention item number 16, lordship. Allow us 4 weeks time to file our affidavit.
Allow
4 weeks time.
item number
16.
16.
Yes, lord.
The petition number.
Okay, learned standing council for income tax. Press for and is granted
4 weeks time.
4 weeks time to file affidavit in opposition. Interim order pass earlier shall continue. Allowed. List this matter on. Give a date after 4 weeks. 3rd of October 2024. Interim order pass earlier shall continue till then.
I do object. May I please, your lordship, beg to mention item number 28, lordship, adjourned for the day, lordship.
20.
28.
Hearing matter. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks.
I believe also. Also, I pray for, I'd like to mention item number 20.
Huh?
This matter become infectious, so I want to observe.
You are Akan, S.I. Akan. Mr. S.I. Akan, learned counsel for the petitioner, submits that this matter has become infectious. Full stop. Accordingly, the petition stands closed.
I am for, I appear on behalf of Respondent number 2.
Mr. J. Handy is present for respondent number 2 and Mr. S. Datta is present for respondent number 1.
I'm like,
Your lordship, I beg the petition for list. Pending before for a long time.
Let me make a mention on Thursday before the regular bench.
wait, please, sir. Who the petitioner is a person belonging to scheduled tribe community, my lord. I have
What is the new development?
new development is, my lord, I have bought an extra copy.
I refuse to keep a copy, madam.
He refused to.
Yes, madam, because by order he has brought this on
No, the
motion.
new development, your lordship will find at my lord. Page number 48, my lord. Page 48,
They
my
have
lord.
been evicted already.
Not evicted, my lord. They have destroyed my crop cultivation. My house is remaining.
What is the reason for eviction, Mr.?
My lord, this is a forest, my lord. It's a 1913 notified forest. And this person, my lord, he has occupied, he has even accepted in his petition, it's a forest land. He's seeking settlement out there, my lord. He has enclosed a huge area, my lord, opened a shop and running business activities, my lord.
Where is this?
Lokhimpur, my lord. And I have also consulted my DFO, my lord. He says that that person is, my lord, trying to mislead me because by revenue records, my lord, he has also he has separate lands, my lord, in civil areas,
You bring on record
my lord.
till then status quo.
Till then,
You bring on record, we'll throw him out.
fine.
K. Burwa, learned counsel for the petitioner, also heard Mr. Gogoi, learned standing counsel for the forest department. Claiming to be a forest dweller and a person belonging to scheduled tribe community, the petitioner seeks protection from eviction of the land occupied, seeking protection from eviction from the land occupied by him. From the pleadings of the petitioner, it is seen that he has not disputed that the land belongs to forest area. However, he has raised a claim of bona fide right so far relating which is available to forest dwellers. Full stop. Per contra, Mr. Gogoi submits that the petitioner is cannot be treated as a forest dweller is as much as he is having land in other areas and he is unauthorizedly occupying a forest area. Full stop. This disputes needs resolution for this dispute needs consideration. Accordingly, let a notice be issued, returnable on
2 weeks, my lord, fixed date.
give a date, returnable on 26th of September. No, what we are doing is we are not issuing notice.
My lord.
uh,
Then, my lord, I can bring it in next week, I can bring it.
okay,
on record.
full stop. Needs consideration, full stop. Accordingly, let, before issuing a notice, let the state respondent file an
Right.
affidavit incorporating the contentions raised by them.
Right.
Full stop. Accordingly, list this matter on 26th of September 2024. Till then, status quo in respect of the possession of the land in question be maintained as on date.
My lord, status quo, both will maintain, my lord.
Both,
We will
both.
not send JCBs, my lord, he will not plan anything.
Okay. Status quo, that is
As on,
status quo by the parties.
My lord,
only thing that he will can communicate them not to bulldoze it.
I'll just come.
Mr. Gogoi shall communicate the order passed today through telephonic mode to the concerned official of the forest department.
Deeply.
Okay, give extra copies.
I'll give.
Okay,
I'll give.
okay. We are not issuing notice, we are not just recording at this stage. The revenue authority, who is representing, revenue is a party?
Revenue is a party.
Yes, who is the standing counsel? So learned council, standing council for revenue department representing respondent number 2 may also file an affidavit or bring instruction as regards the status of land which is under possession of the petitioner, as well as whether the petitioner is having any other patta land settled in his premises.
Obliged. Deeply
My lord.
obliged.
My lord, Dr. Saraf is repairing, madam, he's 2 minutes, madam, but he is here, your lordship. 2 minutes.
So I have serious doubt.
No, madam, he's here.
Maybe.
My lord. 2 minutes.
Go and file a injunction application for injunction.
Case is, my lord, city council is advised.
PP is not here. Okay, wait for some time. Mr. Amit, wait for some.
Thank you, Your Lordship.
Yes.
Lordship, I'm on behalf of MS Roy for respondent number 1 to 4, Your Lordship. We have filed our affidavit in opposition today, Your Lordship. So matter may be taken up on Friday, Your Lordship.
Okay, an affidavit in opposition has been filed in the IA. Same is on record? When we filed?
Lordship, today we have filed it, Your Lordship.
An affidavit in opposition is filed in IA by the writ petitioner.
Respondent number 1 to 4.
Writ petitioner. Same is not on record.
Lordship, there is a similar matter.
Accordingly,
WPC
registry
5527.
to verify and take the same with the record. Yes,
There is similar matter, Your Lordship. WPC number 5.
what similar method?
Same cause of action, Your Lordship. That may be tagged together, Your
If,
Lordship.
list this matter on not Friday, day after next week. Not Friday, day after Monday, Tuesday,
Wednesday.
11th of September 2024, along with WPC
WPC number 5527 2023.
5527/2023. Interim order, Passalia shall continue.
Oblige, Your Lordship.
Yes, next.
Sorry, my lord. In fact, I was told that your lordship takes up first orders, and so in that confusion, my lord,
No motion generally take, yes,
under very peculiar circumstances, I have to approach your lordship, you know. Lord, I
civil
filed-
suit,
I-
injunction.
I-
You file an injunction in the pending
No,
civil suit.
I filed a complaint as SP. I filed a complaint petition.
Hmm.
Now, FIR, it has not been registered, there are cognizant offenses are there.
I approached the SP also and meeting the especially no action has been taken. Complaint petition I filed, it was transferred judicial matter first class and he had fixed up in 12/9. So in the meantime, Delhi there, these bills are coming. My prayer is only that no FIR when the communal offense, it must be registered. Without registration of FIR,
But
they are not-
then you will have to instruct Sakiri Basu to go to the magistrate.
I don't. Huh? But we have gone to the magistrate, not, we have filed a complaint also.
Where is that?
So the complaint at price. Because of. And the
Yes,
order you are.
Goswami, have instruction. You are taking it up day after tomorrow or at 2. At 2. No, Thursday at 2. Things
Only
police
thing
in
is
action.
that These are people who are not certificate I'm posing it. And they are with the guns, they are coming and Delhi, they are destructing and all those things, the police is sitting there.
Okay, have instruction what happened to the, where is the FIR?
Yes. 112. And complaint at page 116.
Page
112.
112.
17th of August, I lost it. Provided a copy to Supreme Taxi also, Supreme Police also, I met him also in the bottom below, you also find that it has been received by Supreme Police. They filed a civil suit also where they have not got an injunction.
Day file.
Yes, in 2024,
Yes, at 2.
About the FIR also.
What happened to this FIR at page 12? Bring the record at 2.
some protection, my lord, otherwise they.
We will pass the order.
No, my lord. Highly obliged. No?
See, if we see any, Mr. Goswami, see, apparently there may be civil dispute. There is no injunction filed by the other side. Now, in that view, if there is a specific allegation of theft and all, you cannot term it as a civil dispute. And if there is a nexus, please intimate the concerned officer in. We know how to handle it.
Well, Lordship, my 145 also, your Lordship, order may see. He has said the poison will remain with me unless and until legal, you know, some remedies or something is there. Now, they have not taken any steps against that one. Page 33, if your Lordship,
Yes,
just.
we'll take up.
Fine, fine.
It's not fixed at 2. If you get the instruction, make a mention, we'll take up.
Just we will have some protection, otherwise we will have these people.
Why don't you go to the civil
No,
court?
I will go, but in the meantime, they are destructing everything and we will not.
Because since civil suit is pending, even a defendant can file a injunction petition there.
But they are.
Isn't it?
But the petition, well, the main, the.
Caretaker has been made a party,
Caretaker
they have not made a party also.
Huh?
Made a caretaker the party.
Caretaker only has been made a party. We have not made a party also. Even then we have filed a written statement also.
And the suit has been kept in abeyance because we
Men-
raised the issue of maintenance.
Mentionability, they have not decided. And will the suit will, what is suit will, they are
Yes.
coming and destructing everything.
I thought you were the plaintiff.
No.
Yes.
Visual loss. My lord, I am applying for response number 16, 20, 24, and 30.
Item number?
This with 19, the orders.
Mr. Goswami, please, what is this happening? Yeah, this is not, they will have to register and act accordingly.
Exactly.
A person fails to get an injunction and does this, and when there is an FIR, they will not register. Complaint is registered. It is fixed after 2 months. What is this? Then everything is to be dealt by writ court. Please.
But
Yes,
this
sir.
writ petition is not maintainable, my lord.
Item number?
Item 19, my lord.
Just a minute. Huh?
Orders.
Item number 19 orders.
That this petition has been filed,
Hmm.
any representative character, my lord.
Hmm.
They have, my lord, espoused this cause of action, some of the villagers,
Hmm.
there without any personal grievance, my lord.
Where
And,
is- who is for the petitioner? What? So many affidavits?
yes, my lord, with these industries, all the industries we are, my lord, running, my lord. We have a consent to operate from the, my lord, Pollution Control Board, my lord. We have annexed also. This petition has failed to show, my lord, how they are personally aggrieved, my lord. This may be at best, my lord, it may be a PIL, my lord.
No, don't say that. Don't say that. Without permission, without authority of law,
We have-
no, if the pollution, if I allege that it is creating a pollution, I am having my lung problem due to the dust, and I raise this grievance and nobody responds me, can it be a PIL? This is my right. This
My
is
lord,
the case.
they have, my lord, my lord, particular, they have to show, my lord, how they are, my lord, aggrieved. Now, we have a permission, my lord, to operate, my lord. That is their, my lord. We have the permission and we have.
Now,
we
why
have the
this matter
consent,
is listed to tell us?
I'm, my lord, paying for the response number 16, 20, 24 and 30.
Why this matter is listed in order?
Cosima order dated 2/8/2024. Only respondent number 27 is yet to be served, your lordship. We may be allowed paper protection.
Why, on whose fault for so many years it is not served? Tell us that first.
2014, my lord.
For
And
whose fault?
Last
Let us
time,
see.
no, there was an order for dusty service. We approved, but they did not receive it from us.
Where is your affidavit? When dusty service was granted?
We have filed an affidavit in that regard.
It is a matter of 2014.
Yes, yes, sir. For the affidavit of dusty service.
Now, what is the stand of the Pollution Control Board? Where are those industries?
It's called Pangram.
Huh?
The village. At Kachar district.
How many industries? In the same village?
The same village, 22.
There were 21, so we have got given the consent to operate to 13.
Ah.
And for the remaining, we have made out a categorical statement that some of two industries are the same, one and the same name. So if your lordship goes to paragraph 4 of our affidavit in opposition.
Who is that respondent upon whom notice is not served?
An industry. They have not received your lottery, even though we have approved. I think
Whose affidavit, Mr. Burwa?
Pollution Control Board.
That is respondent number?
Number 7, 8 and 9.
7. Dated? When have
29th
you
of March,
filed?
29th of March 2019. So this affidavit was filed in 19 only.
Hmm.
That apart, recently we also asked the board to have a inquiry and find out the status of the stone crusher units which are operating at the moment. So from that, we could make out that 13 stone crusher units, 11 stone crusher units have been given the consent to operate. From which among these 12, one has already been closed. And what I can make by telling with the numbers of the respondents, 6 are here named in the respondent list and the rest are different. So maybe some new stone crusher units have been added apart from the ones which has been alleged by the petition.
File an affidavit. And how can, what is this area? It's a forest land.
No.
agriculture.
Stone crushers, there must be query of stone.
Definitely, when the board gives the consent to operate, they.
Forest
acknowledge
is
it
a
all.
party. 13 stone crusher in the same place. There must be some source of for such stone.
There is a Madhura river and there is a quarry. In that there is stones are available.
There are some PILs, what happened to that?
Yes, some are sent.
Excuse me.
Yes, we want Forest Department, Standing Council. What happened to the PIL? Mr. Council,
Yep.
what happened to the PIL investigation? Many things are there. Are you not aware?
Yes, in
You
one-
must be aware.
In one PL, Lordship, I am
What happened to that?
there was a direction disposed of by giving one committee was formed with the IIT. They gave a recommendation that's only that much of.
So how nothing remains to be decided if PIL is decided in that method by division bench.
Was in respect of
Same area, Madhura River.
Madura River is there, but not relating to the stone crusher industries, Your Lordship. That was
We'll bring that, just bring that order.
on the next Your Lordship. Thank you.
Yes, yes.
There are some judgments, I recall. Madhura River, there was initially police investigation and everything was there, then thereafter a final judgment.
To file an affidavit in this regard, recent one, Your Lordship.
No,
Pollution
no.
Control Board,
First, let them substantiate.
Lordship.
First, you substantiate. Now, you have that copy so that we can specifically ask the forest department whether the subject matter of that PIL and this area within
Will
covers the
come
same
together.
matter ends there.
Yes.
He's aware. He's not disclosing
He's
his
not.
card today. He was the council in the earlier Borak Valley, some youth organization, isn't it?
PL I was there.
You are
There
the
was series
petitioner.
of PLs.
We are also informed of things.
That has been disposed of.
So you must say first that this is the judgment of the division bench. Please pass a similar order here. Where is that? Now we'll question what is your intention. And we'll ask to investigate who are you. Isn't it? So bring that order. It is submitted by, in whose mouth will put this, that there is an PIL, in your mouth or in his mouth?
Let it be in his mouth because he was the arguing counsel. So he has a better knowledge about.
It is submitted by the learned counsel for the petitioner that a PIL was filed relating to illegal mining in Madhura River, and the such determination made in the PIL may throw some light on determining the present writ petition. Accordingly, he prays that he may be granted a week's time to produce the aforesaid order. Prayer is allowed. List this matter on next week. You must be aware of all this development. What kind of businessman are you? Or pollution goes permission, we can very well see when it comes to the environment and public interest. Forget about all these technicalities. If he makes a statement that I am a villager, in my village this is done, that's enough for us. When it relates to this mining, you don't have any right to do that. You don't have any right to. It's like wine business. Mining, we are not questioning. If we'll examine it. His proof will come when we'll ask him question, will come it. The moment you open the file and you say that this is not maintainable, sorry. More particularly when it involves environment and public health, as simple as that. One interest is a business interest, other is a health interest. We have to balance. Yes, it is to be balanced.
Yes.
It is that's why in this kind of petitions we will not close being not filed by the proper authorities. There are number of judgments we can very well take care of, even not PL. If you want that, I can bring it.
Intention they have to file it.
See, if the intention is bad, even we can throw them out from the court. till then we can enter into the merit. If we are satisfied that yes, there is something, there is something wrong. Read, we are slowly forgetting that read court's hand is very long. And it can reach anywhere and everywhere injustice is being done. Please don't argue all this before this court. As simple as that.
One thing
Yes.
is important, Malab, last 10 years, if they are very much interested, they are keeping work.
That will look into, that question we have put, but
They have kept
that will look into. But at the same time, we may say that we are not entitled, we may very well ask the police and contribute on a specific report, what is the present status. We may appoint somebody sitting here as a commissioner to go and give a report. Yes, next case.
Obliged.
My please, your lordship. I am appearing for Water Resource Department, your lordship. Yesterday, we have filed one IA for vacating stay and one affidavit, your lordship. May I pray,
Have you paid?
lordship?
Have you paid the amount?
No, your lordship, we have asking the, continuously, we have sending letter to the deputy commissioner for demarcation of the land and to submit the LA estimate, your lordship. But nothing has been done by the deputy commissioner. your
Yes,
lordship.
deputy commissioner.
In this case, we file affidavit, Lordship.
See, your specific stand is that there is no land acquisition.
Lordship.
And the case of the petitioner is that without land acquisition, our houses are being demolished. We understand this is a construction of dike. There are many provisions in the Land Acquisition Act when you can take possession, when there is an emergent nature. But you'll have to pay money. And they are saying we are ready to pay, deputy commissioner is not initiating. Then we'll hold the deputy commissioner guilty and we'll ask to pay from his pocket. Because we'll have to balance public interest and the interest of citizen. What is this? When to be listed? Tell us. Give a date. This IA is for
I have
vacating. It will be difficult until and unless you say that subject to acquisition, we are paying this much of amount, at least according to you, what is the assessment? Tell us that. Deposit, then we'll think. Otherwise, it's difficult. The name of public interest, you cannot go to that extent. Because law is clearly says, yes, you can do it. Urgency is there, you can do it. You can acquire it, you can require it, you can immediately pay some amount subject to final consideration. But this is not the way. Where will they go? It is submitted by the Learned State Council that an IA has been filed, registered. IA has been filed by the state. Full stop. Same is not listed. Accordingly, list this matter on 11th of September 2024 along with IA serial number. Give the serial number. IA with serial number 20. Yes.
May I please, your lordship? Lordship, order dated 17/7/2000. If it has been filed, they have immediate lordship. Their name.
What is the subject matter?
Challenge to one notice, lordship, by which circle officer has interfered into a private dispute between petitioner and respondent number 4.
Any stay?
Yes, lordship.
Where is that? Where is that notice?
Page number 47, lordship.
Who filed affidavit?
The petitioner. Page number 47. This is with
Page number?
47, lordship. Translated is page number 46.
Where is the complaint filed on the?
That was not served upon us, lordship. That was not served upon us. Even lordship, we don't know what is there in the complaint.
Any affidavit filed by circle? What is it? Why have you called them?
Private respondent knows the widow, Lordship. He was
Huh?
private respondent is a widow lordship. He was ousted from the home for his house lordship by the petitioner lordship because there is an agreement with her
So we
husband
understand there is an agreement for
Lo-
judicial between A and B.
lordship.
B was ousted by A.
Lordship.
Okay, fine. Now, what circle officer will do?
Because she has.
Just file a complaint, okay?
lordship.
What the circle officer will do?
FIR was lost lordship.
FIR has lost, let the investigation go. What circle officer will do?
So he was called for hearing, but he did not appear lordship.
Why should he go without authority? If you call him tomorrow, then please come, we'll hear your case. Will he come? What is the business of the circle officer? Who is for the respondent, lady?
Name shown lordship.
Even lordship, there are.
Why this matter is listed today in for orders?
By order mentioned.
Who mentioned it?
We lordship. In between lordship, the circle officer circle officers possessed us lordship. Now we are not in possession.
File an affidavit. How do you know that? You file an affidavit, serve a copy to him. Now circle officer has become adjudicators. Okay.
Now lordship, we are not in possession. Even lordship, the possession was taken pursuant to the sale agreement lordship. We paid an amount of rupees 29 lakhs lordship. Even lordship, on the last date lordship.
So
instead-
that we understand that both of you will have a civil.
Yes, Lord.
Since we cannot decide her case, circle officer cannot, we also cannot
Yes,
decide
Lord.
your things. But we want to know the authority of the circle officer and how he is being appointed as circle officer. This person should file affidavit who has issued this notice. There is a limit to everything. Yes, day after tomorrow. The grievance of the petitioner is that arising out of a private dispute, the circle officer, which revenue circle?
Patasar Kusi lordship.
Patasar Kusi revenue circle. The Patasar Kusi, the circle officer of Patasar Kusi revenue circle initiated a proceeding for determination of a civil dispute between the petitioner and respondent number 4 and accordingly issued a notice questioning the jurisdiction of the circle officer to initiate such proceeding. The present writ petition has been filed. It is in the aforesaid background, this court, while issuing notice, passed an interim order of status quo. Full stop. It is submitted by the petitioner that the counsel for the petitioner that in the meantime, in spite of the status quo order, the circle officer has ousted the petitioner
That I have to take lordship.
from the possession of the disputed land in question. Full stop.
It was done before the status quo order lordship.
Okay, not. However, prior to the status quo order, the petitioner was not after. The petitioner was ousted from the suit premises. Have you stated in the petition?
Lordship, thereafter lordship, after filing the petition lordship.
Was
before the-
ousted,
Yes.
ousted after filing of the writ petition and before the status quo order was passed. Full stop. Let the petitioner bring such facts on record by way of an affidavit. Full stop. The circle officer has not filed any affidavit. Full stop. The circle officer shall file affidavit under what on the following pots. Under what circumstances the circle officer had issued the notice issued to whom? Mamoni Rajbangshi.
No lordship, notice issued to me lordship.
Where is that?
Page number 47
That
lordship.
is to Mamoni Rajbangshi.
Thereafter lordship.
Okay.
Abedankari and thereafter.
Under what circumstances the notice dated 11/6/2024 was issued to the respondent. Full stop. The circle officer shall also explain his authority and jurisdiction, issue such a notice inasmuch as the notice itself reflects that the dispute is relatable to a dispute of sale and purchase of a plot of land, of a patta land, Full stop. The learned, the circle officer further clarify whether the petitioner has been dispossessed by it, and if so, under what authority of law. Such affidavit be filed by the concerned circle officer on or before today is today is 3rd. On or before 13th of September 2024. List this matter on 18th of September 2024. If no such affidavit is filed, the circle officer, Bozali Revenue Circle, shall personally remain present before this court.
Highly obliged.
Please, your lordship.
Yes.
This application is directed against the arbitrary and illegal action of the banks, respondents 6 to 9.
Okay, just a minute. How many order methods are there? How many orders methods are there? This is last.
May I, my lord?
Okay.
Hello.
We are going for final disposal.
Yes, my lord. This application is directed against the arbitrary and illegal action of the banks, respondents number 6 to 9, in freezing the bank accounts of the petitioner society, a society of persons registered under the Societies Registration Act, which came into being in 1990. So the certificate of registration.
Where is the impugn order?
The order impugned, my lord. The order impugned is at page, well, there are 2 letters. There are
Just
two-
will see. Yes.
There are 2 letters.
Which were
Annexure 20, pages 240 to 241.
Annexure 20,
Pages 240 to 241.
240.
Pages 240 to 241.
Annexure
Annexure 21. Pages 242 to 243.
242,
My lord.
242 to 243.
Yes, my lord. These are the 2 annexures. My lord, kindly, if your lordship may take up any one of them.
Just a minute.
Identical, my lord. Contents are identical. City annexure pages 240. Last paragraph. my
Just
lord.
a minute. Just a minute.
Paragraph 3.
What is this IFCI?
My lord, it is a company. My lord, it's a government of India institution. My lord, what had happened?
What is the full form of this?
Industrial Finance Corporation of
Corporation.
India, my lord.
Is a government of India
Undertaking. Yes, no doubts about that, my lord. A few persons had gotten together in 1990 to form a society. The first society is at page 29 of your lordship's brief.
No, this is a part of the board of directors.
No, my lord, not a board of directors, my lord. First society is the group of persons who form the society.
Okay, where is that?
My lord, that's at page 29 of
When
your
it was formed?
Beg your lordship's pardon.
When society was formed first?
In the year 1990. To page 26 is the certificate of registration.
Page 26.
My lord. It's a society of persons.
Just a minute. Page 26.
24/1990, it came into being.
Just a minute. Okay, page 26.
Oh, to the other-
Page 20 is MOA.
Yes, my lord. Part of it. Photocopy to that. Got it? Like this registration act on there. Formed under section 1 of the Societies Registration Act.
Just a
And-
minute. What is the composition of the society?
Well, at page 29 of your lordship's deed. First members of the
Now,
society.
where is the rule of the governing body? First,
A role of the governing body. Well, I'll come to that.
no, will come.
Governing body, clause 11, page 33, madam. Entrusted with the management, superintendence. and
Clause,
control.
clause, page
Clause 11, page 33 of your lordship's brief.
11, page 23. Page 23 is the prayer.
No,
The memorandum starts at page 27, as you said now.
yes, my lord.
2020, it's annexure 1 starts at page 25.
Yes, my lord.
So it cannot go back beyond 20
33, my lord.
or 33. Okay.
Has your lordship got it?
Just a minute. Just a minute. I'm just having a.
Sorry, my lord.
Where do we get the sponsors?
Sponsors, my lord, at page 32, my lord.
No, any definition of sponsors? Who will be sponsored?
Sponsors, my
How
lord,
the society?
that is not there. Sponsors is not their definition.
No, general body says that it is be constituted with so and so, so and so.
Yeah.
Sponsor will be permanent members of
Permanent
the
members of the
society. Now, who is
society.
sponsor?
Sponsors are persons.
No, no,
who-
anything that we know. Sponsor somebody is fine because
Yes, putting in money into the society.
see,
the group of
as come
persons.
Gramin Vikas Bank.
Yes,
Gramin Vikas Bank is a regional bank. And bank constituted under Regional Banks Act. Now, Regional Rural Banks Act itself says the bank is to be constituted and sponsored by a nationalized bank.
yes.
So how it is defined here? Who is sponsor? Sponsor may be Mr. Madam Sharma also, if she is having money.
Mostly used thing under the act, my lord. They're an informal group of persons, my lord.
No, no, they are,
Informal, under
now,
the society's registration.
anything on the
Section
role of
1,
the sponsor.
Section 1, my lord.
All the members cannot be sponsors.
All the members cannot be sponsors. There are institutional sponsors. There are charitable trusts, benevolent societies, academic bodies, my lord. Persons who can put in money.
Okay. Yes.
This was formed under section 1 any 7 or more persons associated for the literary, scientific or charitable purpose, or for any purpose, any such purpose as is described under section 20 of this act, the Societies Registration Act.
No,
made
no,
by
sponsors is defined. What are you saying?
Well, these are persons, my lord.
No, sponsor is defined. Come to clause E first, definition.
Definition, my lord, clause E.
Sponsor shall mean IFI, IFCI, and such other central financial institution as may be recognized as sponsor by the governing body.
My lord, page
Page 27.
27. my lord. Yes, my lord, that is there. In there, my lord, sponsors shall mean
No,
IFCI.
that's why without definition of sponsor,
Yeah,
how
it is
can
there.
this?
It is there, my lord. So, I'm sorry. And such other financial as may be recognized
So
as
the
sponsors by
authority
governing
who has written is a sponsor.
Yes.
There is no doubt about that.
Yes. No, my lord, at the initial stage, not today. Initial stage, yes, they had put in some money, and because
So
they
they
had
are
put in some
sponsor
money.
in terms of memorandum association
Yes,
or
my lord,
Rashtriya Gramin Vikas Nidhi.
Yes,
Now, where is the change in the memorandum
the
association?
change, my lord, why that change had to happen? Well, why that change had to happen? That's very crucial, my lord. If your lordship may come to page,
When the change happened?
change happened, it was uploaded on 7/11/23 in the Registrar of Societies. What had happened, my lord, in the meanwhile? I'll place my lord. Kindly come to the clause relating to the governing board, page 32.
Page 32.
The governing board shall consist of not less than 7 and not more than 21 members, excluding non-rotational members, that is executive director and nominees of sponsors, as may be decided by the general body from time to time. IFCI shall have a right to nominate 2 members and each of the other sponsors shall have a right to nominate 1 member. Other members may be co-opted by the governing board from amongst prominent personalities in the field of education and entrepreneurship, industrialists, representatives, financial institutions, agencies, other persons whose expertise may be valuable to the society. But his position, the chairman's position under this, the earlier memorandum, is, well, kindly come to vacancies, page 33. Society shall function notwithstanding the absence for the time being of any member of the governing board. Proceedings of the general body or the governing board shall not be invalidated by the existence of any vacancy on account of the absence of any member or otherwise. Well, respondent number 3, who was the erstwhile chairman, there is a letter from IFCI now that he is no longer the chairman of RGVN. He had never attended one meeting. After he had taken over, he had never attended one meeting, even the last meeting, which was signed by respondent number 4, the executive director. He had refused to attend that meeting. And the minimum number of members in the governing board had fallen below 7. The executive director—
Fallen below 7 means? By virtue of?
The governing board, because by means of rotation, life is only for 3 years. Repeatedly, letters were being written. Let us co-opt members from the local place so that the institution from the Northeast, so that the institution which works in the Northeast continues working. That was not acceded to by the chairman. This person, respondent number 3, who is now the SIDBI chairperson. What had happened, the society's existence was at peril because it could not file its returns under section 4, under section 12 with the society's registrar. Repeated letters were written.
By whom?
By the executive director as an employee in the society. He had written to them that let us increase in the board meeting.
Who is representing the IFCI?
Before that,
who is representing IFCI?
My learned senior colleague.
Mr. Sharma?
Yes.
IFCI?
Yes.
Repeated letters, they, in a letter, they say that we have taken this up on the last meeting, that is 19/6/23. Has your lordship got my note, my written note? Serial number 4, my lord.
Just a minute. I want to understand that functioning of this society.
But it's a group.
Because whole things will depend upon that functioning.
Yes.
First question will be, who are you? You claim to yourself to be the society itself.
Yes, my lord.
Is that it?
Yes, my lord.
You are represented by whom?
By the board, my lord, I'm by the society, by the executive director, my lord, of the, he has been
Now, where
authorized.
is the board's resolution?
Board's
Where is the
resolution.
chairman?
My lord,
Why
I'm
not
placed.
chairman?
My
Why
lord,
not chairman?
my lord,
Because
that,
see, until and unless you say the nominee of the IFCI shall be the ex officio chairman of the governing body and the society.
yes, my lord.
So a society is to be represented by the chairman, not
Yes.
by an employee.
No, my lord, not the employee. It is the board now, the fresh board that has come into existence.
Now, therefore,
the
how the fresh board can be
The
constituted?
reason is the number of members in the governing board.
No,
had-
that reason we cannot determine in this.
It is in the suit. Now the
That is in
question,
the suit. This
that
we
is in
cannot
the suit.
decide.
We are not, that is
We
not my
cannot,
prayer.
we cannot.
That is not my prayer.
Yes.
What my prayer is, while the two suits were pending
Hmm.
in the learned court below,
Hmm.
the society had filed its suit against the IFCI on 30/9/23. 11/7/24 is this letter from
No, you tell us that that's chairman or IFCI is not having any authority under law to write to the bank. That's
It
all
is
in
not
the
the chairman, my
in the structure of the.
it is not the chairman who has written this
It is
letter.
by the
No, my lord.
IFCI because
No,
IFCI is the sponsor.
It is the chairman, my lord, who is authorized by FCI. This man, he is a deputy general manager who has written
Maybe, but this is
that he cannot. And my lord, the banks
no,
acting
no.
on that
Please,
letter.
madam, listen to us.
My lord.
Until and unless you say that this structure has by now changed with a statutory approval, that this IFCI is having is like a general member.
Yes,
Because
my lord.
under the scheme of the original MOA, IFCI, if we go to the scheme, the Union of India is having control over the IFC, control over the Gramin Vikas Bank, or what is this?
No, my lord, no control. Government has this
No,
institution.
no, control, because if you go through the scheme itself, it says finance will be made by the IFCI or other
Yes, my lord.
financial
That will
institutions.
change.
IFCI should be the nominated member.
My lord,
Board shall have
Kindly,
maximum representatives of IFCI.
Kindly-
Now IFCI writes that we do not recognize this committee, so stop the bank account from functioning.
That they cannot do. That can only be done, that is admitted by the banks. That is the only question before this honorable court. That can only be done if the funds are relatable to terrorism, if the funds are relatable to the proceeds of crime.
Suppose if this accounts belongs to me,
Yes, my lord.
I also cannot stop operating the bank account.
Yes, my lord. That is exactly the question. How can the bank, and bank has admitted in the state bank in its affidavit has admitted they have acted on this letter and they cannot, my lord. It is only under the UAPA Act, only under the PMLA Act or the RBI circular which has been annexed to this writ petition that the bank
So
can.
you want to say, suppose we are having a bank account in Panbajar, Guwahati High Court.
Yes,
Guwahati High Court through the register cannot say that please stop our bank account.
yes, my lord.
Cannot.
Exactly.
Cannot.
Yes. That is it. And if they are to do that, the bank has admitted that they have done it on the strength of this letter. This is a letter which does not disclose the existence of the two suits. It's vitiated by fraud. And they admit fraud as defined in the celebrated K.D. Sharma case. Well, that they have admitted it is on the strength of that letter they cannot do that, my lord. That power is accorded to the central government under the UAP Act, the director, the deputy director under the PMLA Act, or under the RBI circular. Nothing, my lord, it does not. They rely on a SOP, the SBI relies on an SOP. Lordship, may kindly come to page. First, my lord, may come to paragraph 10 of their affidavit. Why they have freeze the accounts. Paragraph 10, they say, bank has acted upon the letter received by IFCI, which does not disclose the existence of the two suits. And my lord, under section 45 ZB of the Banking Regulation Act, then too, if there is a court order against me, a bank account can be frozen. There is no court order. There is
But
no.
they are saying that this bank account does not belong to you. You are not the Rashtriya Gramin Vikas Nidhi. That is a subject matter. Who is Rashtriya Gramin Vikas Nidhi is a
That is to be established.
subject matter there. So till then, IFCI has says freeze the bank, freeze the bank.
My lord, that is hitting below the belt, my lord. Kindly see, bank has itself stated that if this honorable court directs, we will release it. They
No, no,
cannot do
bank-
that.
Bank need not say that.
Yes, my lord, bank cannot say that.
Can they say that if court directs us, we will not release?
No.
Can they say that even if bank directs, we will not release? Can they say? They cannot. So this statement is having no value.
My lord, they.
Now,
they-
please tell us. Yes,
ma'am.
this matter seems will take some time for hearing.
Yes.
Prima facie, after hearing you for some time, this court is of the view that there is no serious illegality committed by the bank. Because there is a question to be answered, who are you and whether you are the Rashtriya Gramin Vikas Nidhi representing the writ petition. That issue is again disputed before the authority. So whether on your prayer we can allow to defreeze the bank, which you may run tomorrow, is a difficult question to be answered.
The question here is,
Hmm.
the question here is that I placed before this honorable court. My lord, it's a society of persons.
No, it's not a general society of persons. It's a memorandum of association says this will be a society of persons where controlling stake will be of the IFCI.
No, my lord, that is nowhere there.
That is there because it will be the sponsor, it will finance. What more is required?
So for all eternity, my lord. Kindly see, my lord, rules can be altered. Clause 30,
No, who has altered these rules?
the board. The board has altered.
That alteration itself is under question.
That is not the question. That has not been challenged.
Now say us where is the alteration of the board decision and
Page 41.
having minimizing the role of IFCI.
Page 41, my lord, which has been uploaded in the Register of Societies.
Who uploaded it?
The board, my lord. Board has uploaded this because, my lord, they ensured that the
Item.
page 41, my lord, for your lordship's brief. Well, they ensured that the number of board members in the governing board of RGVN fall below 7. The returns could not be filed. They existed.
Where
my
is
lord.
the new MOA?
Page 41. It begins at page 41 of your lordship's brief. This was preceded by an EOGM and a resolution in the 98th board meeting. That is part of the suit, my lord. These questions are part of the suit. While the suits are pending,
No. What is a part of the suit? What is a prayer in the suit?
suit is the prayer, not the IFCI, the chairman should not interfere with the affairs of the society.
Where is that suit?
Suit's prayer, my lord.
Suit.
Suit's prayer is at page. I'll place it. Page 81,
Sir,
page
should be the representative. Bank.
my lord. Chairman of city.
I have just
Okay, that we understand.
No, my lord, now my prayer is not against IFCI per se. It is the action of the banks. My lord, the question that is begging for an answer before this honorable court.
No, before that, we'll have to answer a question whether public money will go to the actual, to those who actually owns it. That is a intrinsic question to
The
this.
society, my lord, the persons, that's why it keeps rotating. The number of persons in the society under the
So
society.
show us the new MOA, where is the clauses?
Page 41, my lord.
No.
Of your lordship's brief.
Where is that resolution?
The bank, the resolution, my lord, resolution to have new members, my lord, at, it is the 98th board meeting on 15/9/23. That resolution was adopted, page 237, my lord.
No, tell me. This Gautam Majumdar,
Yes, my lord.
how he becomes chairman of this?
Yes, my lord. I'll come, my lord. Lordship takes up.
Is he representative of IFCI?
No, my lord.
If he not IFCI, how can?
My lord, I'll place what has happened.
No,
He-
what's had happened is we cannot say,
It's-
until and unless you say that prior to his appointment, the MOA was changed
Yes, my lord.
and IFCI was removed because
Yes, ma'am.
IFCI should be as per the MOA will be ex
Yes, ma'am.
officio chairman. That's all.
That was removed, my lord.
Where is that resolution?
That changed, but the resolution is at page 237, my lord.
Page?
237 of your lordship's brief. Yeah. 136, my lord, it begins. He never attends, my lord. Notice was sent to him.
236.
Yes, my lord. These are the only persons, and no meeting is invalidated. According to the original MOA, no meeting is invalidated by his absence, my lord. He never attended a meeting. All this is part of the suit, my lord. What he does is.
No. Show us the resolution whereby you have changed the memorandum of association
Yes,
showing
my
that
lord. It was taken.
IFCI will
page
no more be
238.
ex officio chairman.
Page 238.
Ah,
Page 238.
yes.
Last paragraph.
Hmm.
The board discussed the delay in the co-option of the new members, which is basically due to the objection of the chairman of RGVN. This man, respondent number 3, who is the MD. Thereafter, it was decided to convene an EOGM at the earliest to amend the MOA of RGVN to conform to the rules of the Societies Registration Act. Well, the returns could not be filed. The renewal
No,
could
these
not.
are your, but where is that resolution
This
that
is
you
the
have taken?
To take an
No, it
injunction.
is a resolution to have a resolution to remove IFCI. Where is the resolution that IFCI is removed? It is MO is amended.
Well, page 238 to 239, my lord.
No,
Not to, the IFCI cannot interfere in the matters of
the RGVN is here.
the organization in difficulty. The following is directed to convene an EOGM at the earliest to amend the MOA of RGVN to conform to the rules of Societies Registration Act. There was an EOGM, my lord, thereafter.
No, madam, please understand.
Yes.
We have given many times. For me, it's clear. Here is a society
There is,
registered under Societies Registration. It is having an MOA.
yes, my lord.
MOA prescribes a definite structure of the society.
Yes, my lord.
That structure includes a role of IFCI. How? Listen to us. How? It says that IFCI will be one of the sponsors. It says that majority of the board members as an individual capacity will have of IFCI. It says the chairman should be representative of IFCI ex officio. So until and unless this provision of MOA are amended, these persons are having no authority. If you want any comment, we can proceed further and subject to anything that may happen to your suit. Because if we are asked to answer all these questions, we'll have to answer. Therefore, I do not think this is a case for vacating the stay. Directing the bank to.
Well, then in that case, well, what would happen is if someone
You
writes-
understand the issue, how there will be many ramifications upon the suit. Because we'll have to answer this question, why we are not entertaining this writ petition. We'll have to answer what is the role of IFCI, what is the role of you, how can a memorandum be changed, and this is valid or invalid. If we say valid, then it will affect their right. If we say invalid, that will affect your right. And we'll have to answer if we.
Truck with the operations of the society, madam. They are there.
No, there is, because the question will come whether this IFCI who has written letter to the bank is having authority to write a letter.
Very well.
Is not it?
Let us for the moment.
So if that be so, no, we have no problem if you still proceed.
No, no.
Just this is a warning
Yes,
so that
I
we-
understand. I
this
understand.
is a
what-
warning and
Yes, I
that
understand.
may, yes.
What is begging, my lord, for an answer is that tomorrow I have a dispute with an organization. Let's for the moment assume it is
See,
IFCI.
question we'll have to answer is who are you first? Then we'll go to other things. Moment we say, who are you, whole suit and everything is gone. And we cannot say on evidence, we'll say on the material
That
available
is-
record.
evidence has to be laid. My lord, here, my lord, the question is that is praying for an answer, my lord, is this, that I have a dispute with IFCI.
Mm.
IFCI writes to the bank that, look here, she is not a woman of character, close their account. Close this woman's
No,
account.
I will answer this question like this. Before that, we'll have to decide that whether IFCI is having a right to write a letter to the bank and whether the
Yes.
bank account is
The
actually in your
control-
favor.
The control of the accounts is not in the hands of the IFCI. It is the president and the secretary.
President and secretaries are the executive.
Of
It
the
is in the hand of the society.
Yes.
Whether you are the society, that question we'll have to answer here. If you want that answer, we can right now answer it. That's why I'm asking, where is the amendment of MOA? Where is the amendment of MOA?
That is there.
That is not MOA and MOA. That you say proposed by sitting some members having an EOD that we should change this.
The
We should change this and file an
not we
injunction.
should change.
We, huh?
Well, the reason is, well, the-
We want to change it and
No,
we'll
no,
file
no,
an.
no, my lord. No, my lord. The reason is, if the number of members of the GB would have fallen below,
So
it had
these
already-
are the,
the-
this
the society
institution
would
may
not
die
have existed.
tomorrow. That we cannot help in a proceeding.
Society would not have existed. What they could not do there, they come and do now, writing to the banks. And the banks in a very arbitrary,
Okay.
even,
Okay, we'll answer.
even under, my lord,
Okay.
only
we'll
thing
answer.
that I pray, my lord,
Yes.
if there is no allegation that the money is the proceeds of crime, if there is no allegation,
That we know, but only thing is that why at your behest we'll start this debate. First, we'll have to have a satisfaction that you have the right to say all this. And to say that, we'll have to say you are the actual society.
Society
There-
will die.
you are the actual society, therefore you are entitled to raise all these questions.
see, one other bank did not act on this letter. When it was responded, they gave us an opportunity of being heard. We answered. That bank did not do anything to the account. But these two banks, my lord, their collusion is very clear. My lord, kindly see, we are protecting the interest of the
Yes,
petitioner.
proceed. It is your- Yes, you proceed.
We are protecting, my lord, this is based on fraud. My lord, that they did not disclose the two suits pending in the learned court below. Let us for the moment, they have the power. Let me for the moment yield that he has the power. Then too, my lord, IFCI did not disclose before the bank that there are two suits pending. First suit was filed by the Petitioner Society in the year 2023. The second suit 1 day prior to issuance of that letter. My lord, fraud hits at the root. This letter is vitiated by
See,
fraud.
two things. One is fraud, one is disclosure and non-disclosure of material facts.
That
See, there is a difference between fraud and disclosure and non-disclosure of material facts.
Hello.
Non-disclosure of fact may not vitiate. We'll have to answer that.
non-disclosure,
But-
my lord, suppression.
Suppression of fact, okay.
Yes, my lord.
Suppression of material facts. What
Yes.
is the material bearing of the pending suit until and unless there is an
My lord,
injunction?
if there is a suit,
If there is an
yes,
injunction,
my lord, if there is a
because bank
suit,
will have to act upon the MOA.
no, my lord, not the MOA. If there is a suit, they can only act if they get a court order under section 45 ZB of the Banking Regulation Act. They cannot act, they will not act. If there is a suit, they will not act, my lord.
If there is a suit, they will not act.
They will
Even
act.
there is no injunction.
Oh, yes, my lord, there is no injunction.
So even there is no injunction,
Either for
bank will not act.
No, my lord, it cannot. It's only under section 45 ZB of the Banking Regulation Act steps
Okay,
in.
so us.
Yes, my lord. Banking Regulation Act 45 ZB, my lord.
Read it.
No notice of the claim of any person
Hmm.
other than the person or persons in whose name a deposit is held by a banking company shall be receivable by the banking company, nor shall the banking company be bound by any
So
such
account
notice.
is registered in the name of Rastriya Gramin Vikas Nidhi. Now, who is the Rastriya Gramin Vikas Nidhi? That is to be decided. So
This letter says there's a dispute between IFCI and RGVN. They do not say I am RGVN in the letter. Nowhere do they say I am RGVN. There's a dispute between IFCI and RGVN in the letter. So we are cautioning you. provided that where any decree, order, certificate or other authority from a court of competent jurisdiction relating to such document is produced.
So therefore, in that view of the matter,
Yes, my lord. They
mm,
cannot touch, my lord. The banks
so
cannot
in
touch
that
the
view of
account.
the matter, pendency or non-pendency of a suit is not a relevant fact. This,
Touch the account.
this is not a relevant factor.
Yes, my lord. They
So what is the relevance of disclosing or not disclosing whether suit is pending?
if they disclose,
Uh,
they have to produce a court order, which they don't have.
Why should they? There may not be court order in a suit.
In the absence of a court order, the bank cannot touch my bank account.
Meaning thereby, bank cannot touch a account unless there is a court order. This is one aspect.
Yes, my
There is no court order. So they in the air cannot interfere or stay the operation of the bank account.
Yes, my lord.
That is fine. But the whole question here is, before allowing you to, that we'll have to answer that you are the account holder in the given facts and disputed.
Yes.
That we can answer.
That
We can answer, and that may invite many liking facts or dislike facts, which is subject matter of the
here's
suit.
the question that
Because
is.
we'll have to answer that.
Yes,
Otherwise,
Lord.
we
Here
cannot
the
say
question
that
is-
you are the owner because they are raising a dispute. You are not
No,
the owner.
dispute that they are the owner is not received, not in the letter dated 11/7. They do not disclose that there is a suit pending in the learned court below. One day prior to that, they file a suit. They do not disclose that. If they disclose that, the bank would not touch. The bank has acted only on that letter. So it goes to the root, my lord. It's vitiated by fraud. It is based on fraud. The action of the bank is on fraud. I'm not on IFCI what they have done. The act of the bank is based on fraud. They have no power, my lord, either under the PMLA Act or the UAP Act or their RBI circular or, my lord, section 102 of the CRPC. Nothing, my lord. And kindly see the affidavit, my lord. The affidavit filed by SBI.
Where is that?
My lord,
Which?
it begins at page 665. Lord,
665.
yes. They say they have partially frozen, paragraph 10. They say they have partially frozen my account.
500.
665 it begins at.
Page 500.
Page 665, it begins at their affidavit.
65. Yes.
Well, they say
655.
665, 665. my lord.
Okay. Yeah, it is up to 664. Okay. Just a minute. Yes.
Well, they say that it is on the basis of that letter. And what does the letter say? Well, it does not say it is linkable to proceeds of crime or anything under the UAPA, PMLA, nothing, my lord, or even that the police are after the petitioners. My lord, kindly come to partial freeze. They say they have partially frozen it. Partial freeze is at page 680. When they can partially freeze? Page 680, address verification, KYC non-compliant, KYC updation overdue, customer profile updation, order from revenue authorities, liable to the bank, fraudulent transactions, death of the customer, government order, nothing exists. None of these conditions exist. It is only a dispute between this man, respondent number 3, and the institution, the group of persons under the Society's Registration Act. So in the absence of this, now they have fallen back on this. They have given the go-by to the PMLA, the UAPA, the RBI regulations, or section 102 of the CRPC, for that matter, or section 45 ZB of the Banking Regulation Act. Now they rely on partial freeze. That also they cannot do. That is my humble submission. The banks, my lord, they cannot do what they did. And my prayer may not be happily drafted. This honorable court has the power to mold the relief. I am before this honorable court not to settle my issues raised in the suit. The huge 500-page thesis that has been filed by the IFCI. I am not on all those facts. But one thing, my lord, that they are hand in glove, the bank and the IFCI, my lord, I'll place. The pleadings are, they bear testimony. Not to the assault. I'll place how they are trying to protect our interest. Page 320, IFCI says they are protecting our interest, and also the bank at page, they are hand in glove, my lord, in doing this to us. I'll place protect the interest, page 670. Both of them are protecting our interest, stopping the activities. The persons, the working in the society, they're not getting their salaries. This is what is happening. The activities are at a hold. There are other corporate houses who have put in money for running their projects through this institution. The institution is dying its slow death. What they couldn't do by reducing the numbers, when that was thwarted of the governing board, they come and do this. Let us kill this organization. Finish it. An organization working in the Northeast, someone sitting in Delhi or UP, doing this to an institution. And what is the conduct of the IFCI, my lord? I ask myself. They had a prime plot of land in Guwahati. They sold that and ran away to Delhi. They've done nothing for the Northeast. Absolutely shameless organization. They're trying to throttle an organization which is working in the Northeast for rural development.
Yes. Anything? Yes.
My grievance is mainly against the bank, my lord.
Firstly, very unfortunate what it has devolved to, that's selling a plot of land. I think
These are not issues. Yes, you argue confined to your.
Judge asked a preliminary question as to who they are and who we are. And there is a date which was mentioned before your lordship.
It come to the answer of the lordship's query. Lordship, let us go to the suit first. What is the suit? Why they have filed the suit?
What is that?
Lordship at the my affidavit, lordship at page 336.
Yes.
336.
Yes.
So it is title suit number 605 of 2023. Who has filed this? Lordship, it is the Rashtriya Gramin Vikas Nidhi, a society registered under the Society Registration Act with the registered number. So through his executive director, who is the petitioner before a lordship now, Dr. Romeo Kumar Sharma, PhD. Now, against whom? Against the chairman of the governing body of RGBN. Then, and also at the IFCI, it is the against the chairman. Now, in the suit, what they have plead for lawsuit? That is at 348. Because the suit lawsuit, there is some declaration lawsuit that this is not, they are in the premises, therefore, they humbly pray, declaring that the defendants, most of the defendant number one have no right to act in the name of the plaintiff organization in its capacity as such. Then declaring that all action on the part of the defendant being arbitrary, illegal, and in contravention of the rule of the plaintiff organization is void. 3, restraining the defendant and their materials or agents from intermeddling with the plaintiff's lawsuit. Now, so according to him, that the defendants are in possession. Now, there is a schedule. What are the schedule? These are plots of land and all that. Then the 2 investment of so and so. Then lordship three is the most important lordship, which is not in the writ petition lordship. That's the whole problem lordship. It is a separation lordship, it's a clear separation lordship. Bank account details valued at total rupees 73 lakhs so and so 493 paisa as on 31/8/2023. Annexer 7. So in the writ petition, it was not annexed. Let us see the annexer 7. In my year, it is there, Lordship. Lordship, may please come to place 401. The documents are not before the court in the writ petition. Two additional affidavit is there. There also these papers are not there. 401, Lordship. Annexer 7 of the plain is the page 401. It is the bank detail, SBI account number, ICICI account number, and IDBI account number. And these are in dispute, Lordship, in the writ petition. They want that no one will intermediate would be here in my right and all that, the prayer, and what they have said in the suit, how their right has come and all that in the suit they are pleading. Page 347, Lordship.
Place,
347.
suit is at page 336.
Yes, it is the plain Lordship, page 347. Para 5 and 6. Lordship, I'll not read the whole paragraph, Lordship, only one line. There is therefore a grave urgency to ensure that the asset of the plaintiff organization. Paragraph 5, Lordship, last 4 lines.
Here is.
There is therefore a grave urgency to ensure that the asset of the plaintiff organization, more specifically described in Schedule 1 herein below, are not alienated, altered in any manner whatsoever. Their prayer, their pleading. Paragraph 6. That this is a fit case for grant of permanent injunction restraining the defendant from causing any sort of hindrance or obstruction to the plaintiff in its governing board, agents, servants, business associates from carrying on as a plaintiff organization and making any alienation in the properties of the plaintiff organization, more specifically describing Schedule 1. Again, the Schedule 1, wherein that Annexer 7 is there. Now, Lordship, there is a miss case, Lordship, which is not before your Lordship in the writ petition. So that is at page 402. Along with the suit, Lordship. Which
For
is
injunction.
sufficient. Lordship, injunction application, right. Which is not there, Lordship, in the writ petition. No pleading, nothing. Miss case is not annexed, that's a different matter, Lordship. No pleading as such. Annexer D, page 402. Miss J case number 979 to 2023. Prayer is at page 406.
I've seen that.
So with these they have started. And here in the prayer also, Lordship, the same thing. These accounts numbers are there. That is why here it is very specific in the Schedule 1. What injunction they want. I am holding, I am in possession, so restrain them from the. Now, Lordship, may please come to page 412. It is the first order passed in the miss case. Not a single order is there in the writ petition, Lordship. Not even mentioned. Not annexed, that's a different matter, Lordship. Not even mentioned in the pleading. First order is at 412. Lordship getting. Instant case is registered in the center of the petition plaintiff so and so and temporary heard the learned counsel for the peruse the record Before passing any effective order, I deem it fit to hear the opposite party, hence issue notice to the opposite.
What happened to this IA?
Lordship?
What happened to this IA?
That is what I want to say. Last order is at 417, Lordship.
Order, my lord, I'm not hiding that.
Now, Lordship, not hiding. It's all right. Page 417, Lordship. Order dated 2/8/24, Lordship. That is the last order, Lordship, in the miss case. Page 417. I have given all the order, Lordship. I'll not go to the other order, Lordship. 417. Parties are represented in view of the order passed in the main suit. This misdeed case passed in this order fixed for 21/9 for necessary order.
Okay.
And in my suit, Lordship, there are 5 miss cases. I have annexed all these miss cases.
What is the suit, your suit?
Yes, Lordship. 562.
Prayer is at 5.
You have challenged that 2022 resolution.
That's because 98, Lordship, I will satisfy Lordship, there was no 98 meeting. I'll satisfy from the record. Just now, Lordship.
I am-
There-
No, my lord, I'm
No, you
not.
take your seat. Where is the prayer?
Lordship, 562 is the,
593.
593 is the pair, Lord.
Five?
593. The last part is started, then 594, 595, 596, and 597.
590?
Up to 597, Lordship. It is 593, it is started, Lordship. Now there is a, I'm sorry. 793. Prosecuted.
This is filed by whom?
It is IFCI. FCI is the funding body, Lordship, Lordship's query, Lordship, that time, Lordship, who was the sponsor and all. I'm not saying it to the syllabus.
So was that.
No, yeah, Lordship, may please come to page 362 of my affidavit, Lordship. Because, Lordship, what I want to show, Lordship, may please take up this, because that page I cannot read, Lordship. How this has come from the office, I do not know.
360.
Not a single line I can read, Lordship, here. Is a copy. I can show you. Not a single line I can read in this petition. Anyway, Lordship, now, Lordship,
362.
the same thing I have annexed.
362.
Page 354.
354.
They
50
only went at 362.
362. Yes,
13.2.
13.2.
Quorum. They said that the 7-member, there is no quorum and all that, Lordship. Now it is specific, Lordship, possibly of the governing board, Lordship. 3-member, including the chairman, shall constitute quorum for any meeting of the governing body. Then, Lordship, the 5. Every meeting of the governing body shall presided over by the chairman or is absent by the member chosen
At
of
the
the
meeting.
meeting, at the meeting. So, Lordship, may please come to my written
But chairman
statement.
will remain chairman in, he's an ex officio chairman. It is not an individual, it is the IFCI.
Yes, yes.
Individual has no role.
No.
IFCI may say tomorrow
IFCI,
you,
this one
tomorrow
says
her.
no.
There is no case of any
I
individual.
don't know why respondent number 3, they have made party and bring him from the, he is not there.
Oh, you are the chairman. Individually you don't, huh?
Former chairman, Lordship.
You don't have any role.
No, my. He is an individual, Lordship. Lordship, may please come to page 476.
476, what is this?
This is my written statement in their suit, Lordship.
Will not go to that.
Yes, Lordship, no want to go. I want to show, I only want to show, Lordship, in the, along with the written statement, I have filed a document, Lordship, 518.
Document?
They
51?
they are showing that there is some resolution in 97th meeting and
518.
518. This is the Lordship can read, unreadable document, Lordship.
518.
Lordship.
June 2023.
Yes. Minutes of the meeting of the 97th meeting of the governing body held on June 23 at Guwahati. Lordship, now come to item number 5, page 520. The mentioned item was withdrawn. It is the item number 5 at page 520.
520, item number
5.
5.
Co-option of governing board members. Now they have co-opted, Lordship. The mentioned item was withdrawn from the discussion in the meeting. The board reserved that a write-up on the proposed selection of methodology and proposed fee structure may be presented before the board of governing board in the next meeting. Now, now, Lordship, their affidavit, page 221. I want to show that how some fabricated document has come. I'll show. Their affidavit, page 221. Nine. Page 221, Lordship. This is the letter.
Page
They-
to page.
Page 221 in their additional affidavit, Lordship.
Yes.
Increase the number of board members, my lord. Yes.
It is on 4/8/2023, Lordship.
Hmm.
Title suit 605 of 24 was filed prior to this. This letter is prior to this title suit number 605. This is not mentioned in the title suit. No pleading in the suit. This 605 is subsequently filed. Title suit. These documents are not there. And what is this document, Lordship? To the chairperson RGBN, respond number 3. Now they want to write that in the last board meeting 2, like the last.
So on 4/8/2023, it was requested to the chairperson to incorporate this meeting.
Yes.
Yes, Lordship, co-op.
Co-op.
There's two,
Now
in
that
two places.
co-op was deferred in the meeting dated page.
This
Page,
is page
520.
520, Lordship.
page
Page 520.
520.
Not only that,
And
Lordship,
then when the meeting was taken co-opting them,
19/6/23, my lord.
no,
23/6.
page 520 is dated
4/8/23.
June 2023.
4/8/2023. And when the subsequent decision was taken?
No, my lord, that was prior. 23/6/23.
No, please tell us. On 4/8/2023,
They
The
have sent a
executive
letter.
director writes a letter to the chairman
Yes.
saying that this person should be co-opted.
Yes,
Is not it?
yes.
Then I'll, 520,
520 is the virtual meeting where he did not attend, my lord. And someone has
No,
signed,
no.
whose signature it is not known.
no, there is a, no, we do not know. There is a resolution that he has shown 520.
Resolution is the minutes, my lord. Yes, that is
Minutes.
the resolution.
That is the resolution.
That's a.
That resolution 5,
23,623.
it says that this is dropped for the time being,
Yes.
withdrawn.
That
Yes.
is.
Is that it?
that is-
So
that
what is the date of that meeting?
23,623.
23/6/23.
Now, how can this letter is again written to him?
Yes.
Okay, this was on
4820.
520 is 23,
23/6/23.
2023. Then again, sir, it was written to the chairperson that this should be co-opted
On 4/8/23.
on 4/8.
What happened?
Then when they
What
have-
happened?
no, no.
Then
Then
what
when-
happened, Lordship? It is not, then what happened? The next page. 222.
Yes,
With reference to your letter number so and so, so and so, so and so, it is understood that the subject matter have already been taken up in the board
It's not
governing.
taken up. That's a lie. my
That's why
lord.
it is very difficult.
the
Lordship,
extent-
when someone is arguing.
I'm sorry.
Giving
This-
running
I'm
commentary.
sorry.
Lordship,
sorry.
is something.
he has not. Yes,
So this is on 5th of September 2023, Lordship, the reply. It is a reply to the 4/8.
Hmm.
What happened? That with reference to your letter number so and so, so and so, so and so, it is understood that the subject matter has already been taken up by the board governance meeting dated 23rd June 2023.
Hmm.
Therefore, no response from our side is envisaged in this matter.
okay.
So it is clarified, Lordship.
Then when they have taken the resolution?
Now, Lordship, may please come to page 209. That is why I am saying, Lordship, how the documents has come.
20?
Page 209.
What is that?
It is the pleading, that D, 209D. It is the pleading, Lordship.
Just a minute. 207, 208, 209, D.
D.
So that is at annexure 19, page 232.
Two 209D, that thereafter, the executive director of the petitioner by his
So
letter
98th
dated-
board meeting was held on when?
Yes,
Well, that was held on 15/9/23.
And when this meeting was held, that earlier meeting was held on 23/6/2023.
My lord.
Then why it is again a general meeting is held on 15/9?
Well, the reason is if the number of members fall
Lordship,
below
this is-
7.
This is something, I will satisfy, Lordship. This is a fabricated document, Lordship. That is what I want to say.
That will be decided. in the
Lordship, any
session.
time,
Evidence
Lordship, the interfering with the
Well,
argument, Lordship, this is not done,
Raising
Lordship.
the pitch, my lord, does not.
I'll
require-
show one by one how this document
Take your
has
seat,
come.
Take your seat. Yes.
Harassment,
I'll
my lord,
satisfy
at the
Lordship.
workplace.
I'll satisfy your Lordship.
Screaming is harassment, my lord.
I know.
Yes, on screaming and interference, we can throw both of you out of this courtroom. That is also makes sure. We'll make it sure. Understand? Interfering in a court
I'm
proceeding, also we can throw you out.
In the said board meeting dated 15/9/2023, the respondent number 3 and the respondent number 5, like in the past, choose not to take part, and thereafter, in the 98th board
okay,
meeting,
okay.
Lordship, get it. Now, Lordship, please see the document. Where is that
No, we're
98?
not we were not digging deep into.
Lordship,
We want to
Lord-
primarily who are who. We now to an extent understand what is what. Then we'll pass it.
only Lordship,
Yes.
like, consider page 232. The whole thing will come out. Page 232, annexure 19. This is the notice on 4/9 for the 98th governing board. Now the minutes are at page
What is the,
236.
huh?
Lordship,
minutes?
this page 232
Yes,
is dated 4/9/23. It is notice for the 98th governing board meeting of RGBN. Lordship get in? Now, Lordship may please come to page 236.
This is when they decided, they resolved to amend the MOU.
Page 236. It is the minutes of the meeting of 15/9.
Page 238.
Now, Lordship may please come to page 238. It is their document.
yes.
Last line, last part, 238, last part. Any other item, delay in co-option of the new member in the board of RGBN. The board discussed the delay in co-option of the new member, which is basically due to the objection from the chairman RGBN, who is the
Who is
MD
the
of IFCI.
representative of the chairperson in this meeting?
Lordship.
Who is the representative of chairperson in this meeting?
He was
No.
absent, my lord.
Not been sent letter, Lordship.
No, no. Well,
Oh,
that
see?
was sent. That will be decided in the
Lordship,
suit.
I'll
Well,
show
these
that.
things will be decided in the suit. Well,
Letter
evidence has
was
to be led.
sent to Manoj Mittal, Chief
Yes.
Prosecution Chief General Manager, to Indrani Datta, former Director, Sri Gayatri Besbura, Professor.
Then Lordship may please come. Now, Lordship may please come
Another addition.
to another additional affidavit filed by the petitioner at page 255.
Their document.
Their document, Lord, not my document. Lordship get it? Page 255, annexer 24. It is the minutes of the extraordinary general meeting of the so-and-so on 27 September 23. Lordship get it? Then 256. Item number 3, amendment of memorandum of association, rule of Rashtriya Gramin Vikas Nidhi. The last line, 7 members in the board, which is posing a major threat as the renewal process, which is now online, will not accept the application without the 7 governing board member. Dr. Sharma added, in the last number of the governing body meeting, the agenda for co-option of the new member has been taken up, but every time it has been turned down by the chairperson. After this same happened, Lordship will take note.
Where?
Lordship,
Yes, yes. Yes, yes, yes.
256, second paragraph. Dr. Sharma added, in the last number of governing body meeting, the agenda for co-option of the new member have been taken up, but every time it has been turned down by the chairperson. After this same happened in the last board meeting held on June 23, 2023, no mention about the 15/9/23. Nothing.
Board meeting.
No board meeting on 15/9/23. Not mentioned.
Okay. Yes, madam.
Well, there is no suppression on our part. We have declared, we filed a suit, they have filed a suit. That will be decided.
Judgment, no.
No judgment is.
That will be decided in the suit. Well, here, the reason they are before this honorable court. For instance, well, this is a group of persons and the board decides, well, what the bank has done, acted on a letter of the IFCI, which there is no allegation that there is misuse of funds, that the funds are relatable to terrorism. In the absence of those two allegations,
Which rule you are harping on, this regulation? What is this regulation?
the RBI regulations, Malad, they appear at pages, I'll place, Malad, 90, I'll place, Malad, RBI regulations. RBI regulations, can you quote us? More pages, quote us. I have annexed the RBI regulation.
Give us the pages.
That is at pages 119 onwards, if I'm not mistaken. 119 onwards to 198.
Which is the relevant clauses?
Page 170. 148 and 170, my lord.
What are the now? 170?
2.18,
117, 100,
148, my lord, clause 2.18,
148.
clause 2.18.
Just a minute. 148, 2.18,
Then clause 2.18H at page 118, subclause H.
H, small h,
Yes, my lord.
Oh.
At page 152.
152.
Then, my lord, I rely on suspicion transaction reports, 165. There is nothing under the PMLA Act. Page 165.
No, 165 is clause.
Clause, my lord, that is clause 2.25. B, small b.
Then
And, my lord, I go back to the UAPA Act,
Hmm.
section 51A.
UAPA section
Section 51A of the UAPA Act,
T1A.
of the UAPA Act,
Okay, then
which says, for the prevention of and coping with terrorist activities, central government shall have power.
yes.
Then PMLA Act,
Hmm.
it is the director or the deputy director thereunder,
Under section
under section I'll place. PMLA. I will place. No, this is society's registration. PMLA Act, my lord, section. Section 5, my lord. Attachment of property involved in money laundering.
then
Then section 102 of the CRPC. Is 106 of the BNSS today, perhaps. And my lord, partial freeze also I have placed from their affidavit. These are the only grounds. These grounds.
so
don't
your whole
exist.
case is that forget about who is he, who is not.
Yes, my lord.
A power exercised by the bank is absolutely illegal. They have no sanction and authority under
Yes.
law.
Yes.
They cannot freeze a bank account on the manner they have done it.
Yes.
Therefore, their action should be set aside.
Yes.
Rest will be decided by the
In
civil
the
court.
suit.
This is your case.
Yes. my lord.
Hearing concluded, order reserved. Day after tomorrow.
I also rely
The
on the,
happiest person is Mr. Chaudhary.
I also
Without Wakalatnama, everything is done.
No, my lord, you lost. You have lost the only one appearance.
I also place reliance on the order passed by this honorable court dated 13/8.
In this case,
Yes.
just a minute. Thirteen eight,
2024.
13/8,
2024. my lord.
20,
Deeply obliged.
13/8, 20. Yes, just write it down. Mr. M.S.S. Sharma, learned heard Mr. M.S.S. Sharma, learned counsel for the petitioner. Mr. S. Sharma, learned senior counsel, assisted by Mr. Gautam, A. Gautam, learned counsel for respondent number. Mr. Sharma, you are for?
I am for
2, 4, and 5.
2, 4,
Respondent
and
number
5.
2, 4, and 5. And Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Datta, for respondent number 3. Arguments concluded. List this matter on Thursday. Not
Deeply.
say we orders matter will take it on 5th for delivery of orders.
Lost. I'm grateful.
Yes, sir. What are the other matters? 12:20. Any information?
They have enquired the matter, they found it civil nature, so they gave a report to the court.
Give a report to the court. Okay, but who will protect, give a report to the court means final report. Did you register an FIR?
They have not registered.
So what report will you give to the court? Ask the police officer to be here at 2.
It was Jorhat Lodge.
Well, if you'll also permit me, I will show.
Then we'll say that property should be ensured and protected by the office.
Lordship, and they have cleared for registration of the case, Lordship. Lordship and direct.
So registration of the case is that we'll get hold of this officer. We will want an answer by next Monday. If it's met on your instruction, if it is matter is of civil nature, if no cognizance has been taken, to whom he has sent a report? Whether any GDN is recorded. And according to us, there's a prima facie case theft. Where is the civil nature? Let him have an investigation, then let him say that these are false case investigation. Then
They have verified the record, Lordship, and
Huh?
they have also informed the circular officer, Lordship.
Below the Lalita Kumari judgment, below the.
yes, yes. Apparently, we prima facie see that this is a. We'll pass this order. You need not be here if you want to go home. Let Mr. Vidya, we'll pass after some.
To me, otherwise, and you'll also see 145, the order which has been passed earlier, 2011. In the plaint also, he's mentioning that that order is there. In the order, it has been sent, clearly mentioned the.
What kind of order you want today? Interim protection.
On the basis of 145 order.
We say status of the property shall be maintained as on date.
Look, the question will there, they will enter and say status quo, police is with them.
That we understand. Then what?
Well, first registration of the FIR and the implementation of the order 145 order, if you lost me, just see the order. For timing, you know.
Okay, we'll come back.
My lord.
We'll come back.
My lord. 35.
Page 35.
My lord.
File a suit. Page 35. Filed a suit. Against the petitioner, against the
Caretaker.
Huh?
Caretaker.
against the caretaker of the land belonging to the petitioner, claimed to be owned by the petitioners, for a declaration of right, title, interest, and confirmation of possession, and in alternate recovery of possession and mandatory permanent injunction. Along with the suit,
Case 79, bro.
an application seeking injunction was also filed, which was registered as, copy is there?
Bro, page 79.
Page 79, which was registered as Miss J case number 67 of 2024. However, no injunction, it is stated that no injunction has been granted. Full stop. Have you entered a appearance? Have you filed
The written statement.
no, by through your full stop.
By the caretaker.
The petitioners has also filed written statement through their caretaker. Full stop. Full stop. It is also on record that where is that 145?
For your page 31, bro.
Page 31. It is also on record that page 31. Page 31.
31.
It is also on record that
As per calculation.
the dispute was also dealt by the executive magistrate Jorhat in exercise of which power under section 145. It was directed that until the petitioners are legally dispossessed, the petition, both the parties may approach the higher court and such order of possession in favor of the caretaker or caretaker, he's the caretaker of the petitioner, was to continue. Full stop. Alleging that having support from the local police officers, the petitioner, the respondent, has forcefully entered into the house of the petitioner and stolen certain properties. An FIR was lodged. Full stop. According to the Dr. Saraf Lanet Senior Counsel, such FIR has not yet been registered, and rather the police is supporting the respondent number 4 and 5, respondent number 6 and 7, who also 6 and 7 who are trying to dispose the petitioner from their ancestral land, and at the same time not registering the FIR, inasmuch as the respondent had also failed to obtain any injunction in this regard. This court, while matter was taken up in the first part of the day, asked Mr. Goswami, learned counsel, to obtain instruction the present status. On instruction, he submitted that the police has not registered any case as the matter is of civil nature. Full stop. This court, from the reading of the FIR, it prima facie appears that there are cognizable offences are made out subject to further deliberation in this case. Considering the nature of allegations and the backdrop of the litigation, this court is of the view that the petitioner is required to be protected at this stage till further deliberation. Accordingly, let a notice be issued returnable after 4 weeks. Give a date. Mr. Goswami accepts notice on behalf of respondent number 1 to 5. Petitioner to take steps for issuance of notice upon respondent number 6 and 7 to register post as well as an AD. In addition, the stay is permitted. Full stop. Considering the nature of allegations and more particularly the allegations of collusion between the police and the respondent 5 and 6, it is provided that the possession of the petitioner should be protected till the returnable date, and the local police station, more particularly the officer in charge of Lisubari police station, police station shall ensure that possession of the petitioner is not disturbed. We'll see on the next day. That is what. File an injunction petition on the basis of this. Yes.
In this service, service of notice has been served with the informant. And
the notice upon private respondent number. Yes, are you appearing?
they are appearing for respondent number 2 also.
2, private respondent. As service upon private respondent is complete, and MS T-Sum has entered appearance on behalf of the respondents. Yes.
Item number 17 they appeared.
17, huh? Okay. Yes, there is there.
Yes.
We have already seen that. Yes, what do you want to say? You want some time? You want to the learned counsel for the respondent prays for number 2, prays for, and is granted. 6 for an adjournment, prayer is allowed. Full stop. List this matter next Tuesday. Tuesday, interim order pass earlier shall continue till that. 10. And what is the next case? Item number 18.
Same notes.
Same.
Out of same.
You are representing.
No, in this case, they are not file local.
Are you appearing?
But
same case.
same case.
2 petitioner.
2 petitions.
So
Out of
this is
same.
that they have same order. Interim order to continue.
Okay.
Mm.
Although it was not part heard before the court number 26, but it was fixed for further hearing as per last order, Lordship. Court number 26.
It is submitted by learned counsel for the petitioner that the matter was heard by another bench on 5/8/2024 and was fixed for further hearing. Full stop. Considering above submission, let this matter be adjourned. The registry may verify and place the matter accordingly before the appropriate bench. Yes,
My lord, hearing this,
go to the civil court. That's all.
so my lord, only my one humble submission is that, my lord.
Okay. We have warned you too many times.
No, my lord, I am not claiming any right and title over a particular plot of land, my lord. My grievance is that, my lord, that the circle officer, after my lord, he has registered the case, after perusal of records, after conducting the hearing, he has, my lord, themselves, that the authority, that the circle officer passed an order, and very clearly it has been written that, therefore, it is true that the field mutation was wrongly done on last so-and-so in the name of Sri Narande, son of late Nakul De, along with other Pattada in the place of late Nakul De by way of inheritance on the sale class land measuring 8 bighas, 2 kathas, 8 lesas of dark number 24 Miadipatta, place so-and-so, so-and-so. Therefore, by way of inheritance, the mutation in place of late Nakul De, the same of the name of Srimati Asubala De, wife of late Nakul De, Sri Nantu De, son of late Nakul De, is keeping in force. After my lord, that is the total that the land, my lord, that measuring 8 bighas, 2 kathas of 8 less.
What is the affidavit says?
My lord.
Affidavit of the respondent.
Affidavit, my lord, so far as the my lord, affidavit of the state is concerned, they have not annexed any record, my lord. That is, my lord, that's why, my lord, I am saying, my lord, they are making an averment that, my lord, so far as the, my lord, the 2 kathas of land is concerned, where the name of the that the respondent number 10 has.
Now tell us how do you entered into the possession of this land?
I'm the absolute owner, my lord.
Okay.
I'm the absolute owner.
Okay.
Now, my lord, that the name of my lord, one person, namely.
You are none today.
None today, my lord. None today. My lord, on the my lord file page 20, that is the order that has been passed by the circle. Page 20, my lord. That is the order passed in hearing. Page 20, my lord. That is the type copy, my lord. The para number 1 to 3, my lord, 3. In written on para number 3, my lord, 3 and 4.
So they are Nakul De.
Dilip De, my lord, son of Nakul De.
Okay, what is their claim? What is their claim?
My lord, initially, what happened, my lord, that's name of the Nakul De. That he is Nakul De.
Okay, this order is fine. There is a wrong in fuel mutation.
My lord, they have not corrected the land record as on today.
Okay, thereafter.
I would like to clarify, my lord, 2 things, my lord. That the state government, my lord, the state has, my lord, submitting the commissioner. My lord, he is, my lord, and in his affidavit stating that, my lord, in respect of 2 kathas of lands, the name of the Dilip there has been inserted. That is by way of, my lord, exchange. They're saying that the Asubala Day.
That is why. So they say that mutation is fine, but there was by exchange of this land, they have come into the possession.
Yes, ma'am.
So maybe for that basis, field mutation was done, not by virtue of legal inheritance, but by virtue of exchange. So, and in that house, she has constructed a house.
Yes.
So therefore, the question is, she claims a ownership on the basis of an exchange, which according to him has been exchanged by your predecessor in interest. Further, so therefore she is in possession. You say, no, I absolutely inherit from that property. Isn't it?
Yes,
so mutation was granted on the basis of apparently we do not know as an exchange deed, and she is possessing and having already constructed a house over there. So therefore they are saying in the affidavit that we are not correcting the record. So you go to the civil court, seek her declaration and eviction. or let her file a counter claim or file a suit declaring that I have acquired this right title of interest by virtue of exchanges. That will be matter of proof. If you insist on, we will comment on it. This is the greatest difficulty what I have seen in sitting in this bench. Everything is brought into the writ court. We'll comment it. Then the trial court will not say anything. High Court has said, okay, fine. That's why I said we are taking a risk. You might have a right over that. We'll record it that maybe this region parties we have nothing to say. Can we decide? Admittedly, she is in possession. Admittedly, she has constructed a house. So what is the mutation? What is the mutation? Tell us.
Mutation, my lord, after processing of the land.
Why processing of the? Why cannot be in the field mutation? Suppose I am possessing a land. There is a field mutation. I am in possession. My name is mutated. Field mutation.
Position.
When you are in, you have inherited. A person died. My father dies. I file an application. See there, I am in possession. This was in the name of my father.
That is.
Please give me a mutation. That has been granted to you
Inheritance.
by inheritance. But at the same time, I was possessing a land. It was a field mutation. Field mutation time, Mondal Kanango got a mutation and reports that he is in possession for so and so year.
After execution,
His name may be mutated. It is mutated, but that will not give her a title. She is claiming that I have got this land by exchange with your father, and I have already constructed a house. Deputy Commissioner says, yes, she is already possessing, so we have not been able to correct this. If you want to comment, we can comment. Risk is yours.
Correct, but
If I am correct, I am either you withdraw or I am dismissing your writ petition. That's all. Relegating the parties to the civil court.
one aspect, they have not nowhere stated that the particular land where is the petitioner, that the other side is.
That is the problem. But they say that this is the house, this is the possession, this is exchange.
Only my limited prayer is that, my lord, I have gone through the record, my lord, that in the circle office also, and I have applied for a certified copy, my lord.
You want some time, you will get your time. If you can bring on record, you will get time. No problem on it.
Aspect, my lord, that, my lord.
What aspect will decide on the next day.
My lord.
But this is sum and substance on affidavit. This is the method.
Yes.
This is your claim.
Lordship, there was a relinquishment deed.
So
On
she
the
claims.
basis of that mutation was
Done.
as your
That is
lordship
her
had
case.
pointed
We do
out.
not know. See whether she is correct or not. We cannot determine.
There
This is her submission.
No record is there, my lord.
The read, whether the read court, lordship has correctly pointed out, how can the read court go into these issues?
So we'll have to say.
That is- Lordship, my lord.
So she has raised a
time.
point. She has raised a
I
point.
will adduce the record.
Huh?
I will adduce the record, my lord, that certified provision of.
Actual aspects and all after these were done. Again, coming.
Let him fight. He's damaging his client. Yes. What to do? We are not here to advise anybody. Under prayer of the learned counsel for you are possessing, you possess it. Under prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks. Holiday scheme.
Matter challenging a suspension of.
Let you stop it, the operation. If they do not accept holiday, give it to somebody else. Matter ends there. Let them resolve and come back to you.
Lordship,
That is what,
on
my
the-
lord, we tried for a very long time, my lord, and there are a series
No,
of.
we have
litigations.
seen who is not claiming. We cannot decide who is good, who is not. What we can decide is that whether holiday scheme is applicable. Their whole case is that holiday is not applicable because there is no fall of sale. Okay. So we'll say that holiday, if not applicable, holiday scheme, you stop operation. You stop operation. You are giving them a benefit under holiday.
Yes.
So don't give benefit of holiday if you dispute their entity itself. So stop operation, give it to somebody
That
else.
is what the impugned order says, my lord.
Give it, then that's all.
Lordship, on the last occasion, it was heard and records were called for. What is?
What record? Tell us.
We have
Who
brought the records, my lord.
can we decide all this? Who is whose son? Who was original owner? Who was having how many petrol pump?
Lordship,
This is not the subject matter of it.
Civil code, there is a pending civil suit also filed by.
So therefore, enjoy the holiday scheme.
Lordship, that is only, Lordship, our thing is continuing.
Who is the private respondent? What is your case?
Last one legal here.
Huh.
The reconstitution scheme.
Who are they?
Your lordship, they are not giving.
You are the sister. Give it to her.
Lordship, what has happened? There are initially.
Let nobody eat it. We are dismissing this petition.
Lordship, it was.
If you are adamant on these points,
Lordship,
One brother given your lordship.
Lordship, IOC has still to file their affidavit on merits here. Lordship, it was hard substantially on the
there
earlier.
is stay order.
My lord, there is a stay order operating for a pretty long time.
Lordship, when Council G. Goswami was arguing today, she is on legs. At
Who
court
was,
number.
who is Goswami? Who was saying?
Gayatri Goswami was arguing, she is on legs in court number 1. And Lordship, on the last occasion, records will call for what has happened. There was a memorandum of understanding in 2006, which was endorsed by the private respondent also.
Please tell us what is your grievance?
Yes, Lord.
Let us not go to here and there. What is your grievance?
Lordship,
What is the action you have challenged in this petition?
it's a suspension of our sales and supply.
Hmm.
Lordship, our grievances is the firstly that suspension of sales and supply is controlled by the market
So
organ.
just tell us, say suspension of sale and supply cannot be done under a holiday scheme. In the given case, in your case, it is the holiday scheme is not applicable to you. Is
Yes.
this is your case?
Yes,
Reason being that there is no fall in sale.
sales.
And holiday scheme is a scheme where they put you in observation.
Yes.
Put you in observation that whether you can be improved, counseling and all. So you are in a holiday scheme. If you fail, then they may discontinue.
Yes.
So according to you, they have failed in doing so.
Yes.
Because it is not a case of holiday, there is no condition precedence for holiday scheme is not applicable.
Oh, not there.
So we'll set aside that. Do you take give him a liberty that if they are not inclined to continue with this thing,
Yes.
they may discontinue
Yes.
on any of the provision
Yes.
they want to do.
Yes.
Your,
That is our case, Lord.
your thing is gone, but we will not protect you. We'll say that they will have liberty to terminate your contract if they
Yes,
question you.
termination is another thing, Lordship. They may terminate. They have the power.
Oh yeah,
But they cannot
that is what
stop sales and supply.
they will terminate. That's all.
They will
Liberty to terminate if they do not recognize this identity, which is having going through a dispute.
Lordship, they,
That will do.
yes, Lordship, if Lordship said
that one.
Huh?
I'll accept that
We'll accept that. That's all because it is not a holiday.
Lordship,
That's all.
that
That is,
may-
see, in a writ petition, what can we do? We can say that IOC action is not legal because it cannot be under holiday scheme.
yes.
This set aside. However, we'll make it clear that this order will not debar to act against the petitioner as they have raised the issue of that this organization is not having legal sanctity. They will do it. Fine. Hard.
Lordship will pass this order only, but Lordship just at 2 in the presence of Jews. That
I do not think, I think this is the issue.
yes, that is the issue.
That is the
Lordship will
issue.
pass this order. So I-
Why should we go? Who is whose son? Who is
That is
whose
civil
grandson?
suit is pending. Therefore, that civil suit is
They say that this is no longer an identity. We have tried to settle, nothing has happened. This is a liability for us, so we want to discontinue. Okay.
We are
They apply the holiday scheme. So you say that holiday scheme is not meant for this.
Yes.
If not meant for this, okay, not meant for this, but they will have a liberty being an employer to continue with a license or not continue with a license. That's all. On the same ground, they can do it. May not be under holiday scheme. Isn't it?
Lordship, under the law, if they have the power, they will do it.
Yes, they will definitely do it. Because if they do not know who is the owner, how can many things are there.
Holiday scheme is giving an opportunity to them to resolve the dispute. And if you cannot resolve the dispute within 6 months, then we give up to 2 years time. And thereafter only, my lord, we give it to others. They are not trying to get that benefit. Also, they said.
We will observe all this, that what is the scheme of the scheme may not be applicable if that may be applied in their executive things also. It's not a statutory, it's a business between you and him.
Yes.
Isn't it?
Yes, Lordship. And
Many people are in the queue to run this kerosene oil or something, or petrol depot.
petrol.
And kerosene oil, both, my lord.
All are people are in the queue.
Yes, Lordship. And it's not that the private respondent has no petrol pump, she has.
No, we are not concerned with that.
Yes,
We are not here to do distributive justice. Please understand what is the issue. We'll answer that only.
Yes. Lordship, I have got it,
Whether
Lordship,
if
Lordship,
they are having this or whether some central government is doing good job in a northeast region or not doing, this is not our subject. We are not policy makers here. When? At two.
Lordship, I have understood, Lordship, sort of. I have
If
understood.
you want
That
to
is
say
the
that,
order. At best, Lordship, we can prefer this order only, at best.
at
this
best,
stage.
that is the order. That can, and Mr. Chaudhary has said we'll do our exercising our executive power. That's all.
My lord, agreed to that, your lordship में पांच दी और
No.
showing her name.
Showing her name.
No. At two, Lordship.
Yes. Tell us, give a date. This is too
Within
much.
December, Within two.
It
within
is
December.
too much, Mr. Chutia. See, litigations, court has even made observation that it is a right is crystallized.
My lord.
When?
My lord, within December, my lord. 2 months, my
We are fixing this matter on 2nd or 3rd of January,
lord.
saying that they will complete payment and give compliance within December.
But the petitioner has put different amount in the petition, my lord. Whatever the amount dues, my lord.
That much. We cannot say this amount only.
They have stated in the paragraph that they are issue direction for 71,35,2000.
No, that part has been paid. Only remains is how much?
But the PR is the page 20.
PR is different. That's why there is a earlier occasion
And
it
the
was
page
recorded.
8 and the different amount is put in the
Amount
we
now
have-
I think
During
241,963.
Well, no, but 21 lakhs, my lord. Wrongly
30.
mentioned. Earlier order, lordship wrongly mentioned.
Okay.
My latest instruction is that, my lord, 24 lakhs, 1,900.
Okay, whatever, let them, okay. Pursuant to this court's order dated 30/8/2024, Mr. Chutia learned that Standing Council for the KASE submits that the actual and admitted due to the petitioner is an amount of rupees
24 lakhs, 1,967.
1,967, and the respondents authorities are trying their best to release the aforesaid amount to the petitioner, and it is on instruction he further submits that this matter may be adjourned and fixed in the month of January, and the payment to the petitioner shall be made by December 2024. In view of the aforesaid submission on instruction, learned counsel for the petitioner submits that since her client has awaited for so much, she can wait for another 3 months. Full stop. Accordingly, the matter stands adjourned and be listed on, give a date. 3rd of January, or you all people will be happy with Christmas and New Year's after Bihu. After Bihu. Date. What no? Give around 13th, 14th is Bihu. There will be last 18th of January 2020.
In this case, my lord, another 3 weeks time you may be granted to file, my lord. Not 3 weeks, my lord.
Give the land or take the acquisition.
My lord, only thing is, my lord, they will file an objection, my lord, because we are the occupying from 1961, my lord, and they are
Then from 1961 you'll have,
73, my lord.
then you'll have to, from 1961 you'll have to give requisition compensation.
No, my lord, then 73 they are sold it, my lord. 83, my lord, then
No,
we did it, my lord.
that we understand,
So-
but their sale may be in 73,
So,
but condition is that whether that land was acquired by you.
my lord, I'm not.
According to revenue authority, you have not.
My lord,
So whose land,
in-
when purchased is not your subject
my
matter.
lord, so far this demarcation was by this, my lord, this not physical but drone, my lord. So we'll sort them 3 weeks, my lord.
I think file an
On
affidavit.
26, my lord, maybe.
So on the last occasion,
You
matter
are-
has been fixed
you-
today,
uh.
at his request.
No,
Lord.
my lord, on last occasion, myself and the architect is out of station. He is also today out of station, my lord.
So file an affidavit,
Yes,
what
yes,
is, what is
yes,
your
my lord.
record?
3x, my lord. On 26, my lord, for
On 24.
26, my lord. 24, I'll not be here, my lord. 26, my lord.
We'll say the assistant,
My lord, he is not today. He is not. He is out of.
no, we'll say him that don't engage Mr. Medhi in Assam's case, because he's a man meant for Arunachal and Mizoram.
The difficulty, Lordship.
My lord,
Most
on
of the
2 days,
time
my lord.
they-
26, my lord. This is the hearing date.
26?
Yes, my lord.
You want 26?
Yes, my lord. 26.
Mr. Medhi, learned counsel for the respondent army
In 1 and 2, my
authority.
lord.
Huh?
1 and 2. For
Respondent number 1 and 2 submits that the affidavit, they are in receipt of the affidavit filed by the circle officer.
Yes, my lord.
However, as the said affidavit is a said affidavit however, in the said affidavit, however, as in the said affidavit, it is asserted that the army is occupying the land of the petitioner. They would like to file an affidavit, reply affidavit to the affidavit in opposition filed by the circle officer, as well as to the affidavit, to the writ petition filed by the petitioner.
Already.
Already
filed,
filed,
yes,
full file, filed by the circle officer. Mr. Deka, on the other hand, submits that the petitioner has already illegally been deprived of right of possession of his from his property, and he has some urgency in this matter. Considering the both of the submission, it is provided that the affidavit, the adjournment stands allowed, however, with a condition that the affidavit be filed on or before 26th of
26 September.
26th of September 2024, and list this matter thereafter on give a first week October, first week date,
1st of October. Lord.
3rd of October. Okay,
1st of October.
Huh?
1st of October.
1st of October 2024. If such affidavit is filed, in the meantime, the writ petitioner or the circle officer may file their reply.
File.
An endeavor shall be made on the.
We'll make it, don't worry, no
Yes,
need,
sir.
we'll make it. Always that endeavor is there,
Yes.
in all cases. Yes. Yes, what is your case? Where is your permission for constructing the shed?
issue lots.
If no, then we are giving you a time, demolish it, that's all.
There is a scope of regularizing the
No.
set. There is a scope of regularizing because the as per the building bylaws, it not
Building
coming-
belongs to whom?
building belongs to the it is a society lot, but it has been perceived, the shops has been perceived by me.
Understand, it is a complex where residence and commercial parts are there.
Yes, lots.
Is that it? So that building does not belong to you.
Lots.
You are owner of maybe a one room, what I can perceive from the petition.
Three rooms. Lots.
3 rooms. Now, in the 3 rooms, you have made some sets,
Lots.
constructions,
Temporary sets.
temporary sets. Now, the society objects to such construction of sets. GMC finds that this is not legal. So, it is to be removed. As simple as that. Where is the question of compound? This is not a building constructed by you. This is an additional construction. And additional construction, even if temporary, without permit, is not compoundable. That's all.
Is that lots if the over which the plot of land over which the shed is constructed, it belongs to the petitioner lots in terms of the cell deed lots. The 1018 square feet lots.
It is a proportionate part.
Lots of land, lots of me kindly.
You show us your agree sale. You have purchased 3 rooms.
Yes, lots.
Your ownership over the land is the proportionate to that square feet of that room. Is that it?
Lots of me produced a cell deed lots.
Proportionate share of land. Or you have been given that this frontage, even so and so
yes.
shall be his property. Where is that?
Page number 34, Lordship. Annex 3, page number 34. The schedule, Lordship.
Hmm?
The schedule, Lordship.
Place number?
Page number 34, Lordship. The schedule of the cell deed, Lordship. Schedule.
That is what saying proportionate share of land measuring 0.25 R.
And last line, Lordship. With exclusive right to use 1018 square feet open area in front of the shop, subject to statutory provisions of law.
Where is that?
Last,
Because standing over slab land measuring so and so. Along with exclusive right of 101 is open area
open area.
in front of the shop subject to statutory provisions of law.
Lordship.
So you use the open area, nobody is disturbing you.
No, Lordship.
But we also peruse the.
Have you applied for construction for this to the municipality?
That is a deficiency on the part of the petitioner, Lordship. Subsequently, he applied for regularization. That has been, that was not considered. And rather the demolition part has been.
Where is that order not considered?
The demolition order has been.
Now, where is the original building permission?
Permission is
By the builder.
Annex 1.
That is there is any school that is declared to be an open area.
Yes.
That's why he have given open area. We cannot help you.
In fact,
See, Mr. Das, we can only legally determine. We can understand that this area gives you a potential to your business.
Yes, sir.
This is just said you might have a shop, something like that, mithai shop.
It is purely for the purpose of securing the customers from rain and sunlight, Lordship.
No,
Not otherwise.
No, I have seen the photograph.
And the building.
No, this is the original photograph. These are the original
These are
photographs.
the
No,
post
even if
photograph.
photographs is there, this is covered. We'll not go whether
Photographs are made such a way, it is like a board. This is the original photographs. Lots will one.
These are the close-up photographs, maybe.
No, we know that. From the board in
Doesn't
fact, in decision, if it decision covered terrace area like this.
Yes, lots will see the next photograph, then there is a parking. I have flagged it.
That parking also constructed by him.
No, Lordship.
Parking is
It is a
because
okay.
I want to show it parking because
Then
the.
what is the objection of the society?
Completely ingress and egress is totally different, Lordship.
That we have seen.
No.
What is the complaint of the society?
Lordship, there is a water source in that common area.
Where is that water source?
That is their
and-
story,
and-
Lordship. It is not a case, Lordship.
And we are unable to, because they are purchasing water for the last 2 years. 19 households.
No, Lordship,
And most importantly,
No, we are not going to all this. Please, Mr. Counsel, show us where is your right to construct a shed over that.
no, Lordship, they admittedly.
Admittedly, let us not proceed further.
No, Lordship,
We cannot decide all these.
But see, at least that after the stay order also, he has received a notice from the GMC, Lordship.
They can run the business. There is not only the state. Well, if Lordship transfer.
This is, we'll take up it at 2.
Lordship.
Mr. I have an instruction from your client by what time, which time he can remove.
Lordship,
We can
only
give-
only thing that.
We can give you time
this
till
is,
the festive season is over.
no, Lordship, this is a notice from the.
After Diwali. After Diwali. Oh, forget about all this. In given cases, we'll get hold of them when necessary, but this is not the case.
No, Lordship, at
Okay, we'll draw a contempt against them, but we'll direct you to demolish this
Lordship,
immediately.
There is a.
We are not giving you any chance for this.
Lordship, there is a notice from the additional commissioner, Lordship, for a fresh proceeding. At least this can run, Lordship. At least the petitioner can place his materials.
Place it as before us.
No, the thing is that, Lordship, there is a scope of regulation. That's what I am submitting,
I
Lordship.
have serious doubt.
I'll show, Lordship.
Where is that new notice?
You have provided me.
Huh?
The notice dated 15/11/22. This notice makes the writ petition infructuous. On the day of 15/11, this writ petition was filed.
What is challenge in this writ petition?
The order,
Where is it?
order at page 49, let's see. The petitioner received a notice, Lordship. He replied. Thereafter, he preferred an appeal, Lordship, for the appeal committee.
Where is the appeal committee?
Appeal is at page 46, annex 9. Lordship.
Page
46, Lordship. Annex 9. Type copy, original at page 47. Lordship.
Now, what happened to the appellate authority committee?
That has been decided, Lordship, at page 49, annex 11.
So this was after this notice has been issued.
On the same day, I have checked, my lord, on the in 1511 it was filed. On the 1511 this notice was issued. That means the petition, even if this appeal is not an appeal, this notice was issued for getting document. It cannot be an appeal. This is not a final order. This is a document.
The concerned appellate authority has given the finding, Lordship.
It said that the extension of the state. This is extension. Thereafter,
That you have invited.
thereafter notice has
That you have invited.
No, Lordship, our prayer in this writ petition is very limited, Lordship, because the portion of land whereupon this shed has been constructed, it has been handed over by the builder concerned.
No,
We
there
have
is
the
no
we have
doubt
the right.
about it. The
We have the right.
builder has got a permission of a building with an open area in front of these 3 rooms.
Lordship,
Okay.
Lordship.
Had it sold to 3 persons, these 3 persons
Yes.
would have the owner of this open space. So the original permission is open space. Therefore, you have been sold the property with a proportionate share of land along with the open space.
Lordship.
I have serious doubt upon their locus standi to seek demolition. That is a different issue. Who are they? Who are you? Society, you are the society of the residential society. Commercial part is sold with an open area. Who are you to intrude?
That is a common space, you know.
Not common space. How can you challenge his sale deed? Do you want to invite all this? He challenge his his sale deed before competent court of law.
Lords will turn to page number 30, paragraph number 5.
Huh? Page?
Page 30, paragraph number 5. Nobody will use that particular area before the top for parking or for any other purpose will be created hindrance to obstruction of the purchaser in his business. No, they cannot use
No,
the
that is
parking. This is a setback area. Setback area they cannot be used for any business. Even that NOC also in the person who are deciding there, they can also use it for.
That is what it says. That purchaser shall have exclusive right over 1018. Who are they?
No, they are the resident. We are not concerned. We are
not concerned
we are
with
not
them.
concerned.
But
We are only regarding.
The process has been initiated at their.
Maybe, but ultimately
If the-
initiated if they found. Therefore, we'll say we'll examine. Where is the notice first? Then everything is done. You have when they have found it.
The thing is that-
Irrespective of them, forget about them.
Lordship.
Irrespective of them, there was a notice, you file an application that was determined, the matter ends there.
So, Lordship, that our prayer for regularization, which has been made before the appellate authority, there is no whisper about that. Why it was not considered, why it cannot be considered, because all
You
this.
plus satisfy us that this can be regularized.
Lordship, I'll refer to the building bylaws.
No, forget about building, so as the building permission.
Building permission, Lordship, there is no mention. Building permission.
What it say, building permission says it is an open area.
Open area, Lordship, Lordship, let's see. Even.
Page 23.
Page
23. Right hand side ground. There will be only shop. Shop, you cannot extend it. There are 3 shop area that will they will be business.
Paragraph 23, where is that?
No, page 23.
Page 23, which?
Right hand side,
Ground floor.
area of floor ground.
Area floor, ground.
0.09 square meter plus so and so square meter retail shop.
There will be show. Nobody will disturb them. They will run their business, but not by extending that shade. Only that shade will have to come down. They will run their business.
And surprisingly, Lordship, there are 4 stops. Stop number 1, 2, 3, 4. One of the stops, stop number 1 is owned by the building, the restaurant number 6, who is representing here, Lordship. There is no action on.
Who will say that?
No,
We'll
but
say, clarify that.
but-
6 will also go.
No, Lordship, my plea is that it can be
6 will also
regularized.
go. We'll clarify it.
It can be
This
regularized.
place is not, it is an open place.
Yes.
Permission is not there. So, GMC is
As per the-
accordance with law subject to your right to prefer an appeal before the statutory authority. You are not given.
No, Lordship,
There is an appeal against that mayor in council before the state.
No, but there before the mayor, there is an appellate authority in the GMC under section 438, my lord.
Ah.
They can go for appeal, but they can go for appeal. Here, he has gone for appeal.
No, there is a provision to go to the state against mayor in council by to the department. Earlier, there is a provision.
But they can file a petition if there is.
No, we are not interfering in this.
No, see, the thing is that why I am saying it is compoundable. The building bylaw says specifically non-compoundable items. Use of building, addition of extra floor, parking norms, projection and encroachment of public land. We don't fall in any of the.
This is non-compoundable.
This
What
is
is
not
compoundable? Let us see.
Except these are specifically mentioned.
No, this is at any rate it can be. There are compoundable things with limit.
Yes.
Where are those provisions?
No,
Show us that.
The compoundable items are there, Lordship. It relates to the building, the actual erected RCC building, Lordship. But
No,
it is not a RCC building, Lordship. It's a GIC
Anything
temporary.
you construct, you require a permission, and anything constructed without permission is non-compoundable.
And one more thing, Lordship. The Lordship has perused the photographs. It is not prejudicing anyone, Lordship. Neither the.
This is not a case. The rules are framed by competent authorities under the Act. With an opinion of expert, they frame certain rules. There is no question of prejudice here. If rule permits, you continue. If the rule don't, you are out.
Lordship, then in the affidavit of the GMC, they are saying it is the aerial encroachment. The aerial encroachment in the private land, it cannot be, Lordship. Aerial encroachment should be in the.
What
public
do you
land.
mean by aerial encroachment? Aerial encroachment mean that you have constructed a shed. That's all.
Aerial encroachment has been defined, Lordship.
Yes, what is that? We are trying hard, but no way out.
Lordship, I have mentioned in my affidavit.
Tell us.
Page number 108, Lordship. The aerial encroachment definition, any projection of an object other than a tree or other planting that is located on private property and projects at least 30 meters above the surface of public lands as measured from the highest point of the object that projects over public land.
Where is your application? Show us that first.
Application for.
Where is the first notice? Forget about all this. We'll not go to the merit, who is doing what. We'll see whether procedure is followed or not. Let us see.
First notice it at page 42. Yes. Annex 7.
So they have simply said that some complaints are received. Please show us your document. Then what you have done?
We have the petitioner filed a reply.
Where is that?
Annex 8.
Annex
Page
8.
43.
Then where is?
Then Lordship, we approach the appellate authority, Lordship, 1 minute.
Now where is the order of the municipal corporation? No order passed.
No order passed. When the appellate authority passed an order, page 49. Lordship.
Then thereafter notice was given.
Hereafter, Lordship, this notice, it is
This
dated
notice came on 15/11.
15, but this petition has been moved on the same day, Lordship. We didn't have earlier knowledge of that, Lordship.
Heard. Mr. Didas, learned counsel for the petition. The present writ petition is filed. Aggrieved. Aggrieved by order dated 9/11/2022 passed by the respondent number 4, whereby the appellate authority under the GMC Act, that is within bracket mayor in council, full stop, the bracket comma, has directed the planning branch of Guwahati Municipal Corporation to start procedure as per GMC Act to demolish the extended portion of constructed shed of the shop of the petitioner. Full stop. The further prayer made in this writ petition is a direction to the respondent municipal corporation to regularize the construction carried out by the petitioner stated to be an construction with the petitioner, full stop.
Said.
Construction within bracket said. The admitted facts as are discernible from the record available that the petitioner purchased, what is that, sell deed?
Annexure 3, Lordship. Page 25.
Purchased,
The schedule is at page 34, Lordship.
purchased 3 shops, is not it?
3 shops.
3 shops.
2, 3, and 4, Lordship.
That is shop number 2, 3, and 4. From one builder, namely Messrs. Siv Realtors. The clause clause 5 of the sale deed also describes that the purchaser shall have exclusive right of use of 1018 square feet open area in front of the commerce or in front of the shop for his own business purpose, subject to statutory provision. It was further declared that such open space shall not be used for any parking or any other purpose which will create hindrance / obstacles to the purchaser in his business. The schedule of the sale deed further described the said area to be an open area. The building permission on the basis of which such building was constructed by the builder also shows that there are shops in the ground floor. Full stop. Admittedly, the petitioner has constructed a shed which, according to the petitioner, a semi-permanent construction. Full stop. It is also an admitted position that petitioner has not taken any permission for construction of such shed. In the aforesaid backdrop, the president of the respondent number 6, the president of the Residents Association of the building lodged and complained before the GMC authority that the petitioner has made a construction of semi-permanent shed with steel structures in front of the said apartment. In view, on receipt of such complaint, the Associate Planner, Guwahati Municipal Corporation, requested asked the petitioner to produce the no objection certificate and approved plan of the in respect of the shop and the construction undertaken. Full stop. The petitioner by communication 26/9/2022 by a reply dated 30th of September 2022, amongst other, the petitioner intimated the Commissioner, Guwahati Municipal Corporation, that the construction is purely temporary shed and do not hamper and is not hampering the commuting public in their daily life, but helping the public consumer. It was a further stand that no objection certificate for the said construction is inherent and inbuilt in the registered sale deed of the shop, and therefore the Guwahati Municipal Corporation is having prior knowledge of it. It was further, a stand was further taken that all evidence, circumstantial and documentary shall be produced as and when proper notice is being served. Ego clicks everywhere. Full stop. While matter was pending before the authority, the petitioner preferred an appeal before the chairman Guwahati Municipal Corporation for regulation of the construction of shed and wall. In the said application, it was from the application, it is seen that the petitioner sought permission for regulation of the constructed permanent shed and wall in the east front of the commercial shop of Jopia for conducting his business properly and safely. Full stop. Such prayer was rejected by the mayor in council within bracket appellate authority by its order dated 9/11/2022 and 9/11/2022 with a direction to planning branch to start the procedure as per GMC Act to demolish the extended portion of the constructed shed of the petitioner's shop and the aluminum partition wall constructed attached to the garage. Full stop. Thereafter, the petitioner preferred an application seeking review of such order. While matter was pending at that stage, notice was issued on 15/11/2022 under section 337 within bracket 1 and comma within bracket 2 of the Guwahati Municipal Act 1974 in terms of 1971 in terms of the appellate authority's order dated 9/11/2022. What it says 337 1 and 2,
Just show cause notice. You
Okay.
have to reply what is
Okay,
there.
okay.
After the final
So
notice.
from the aforesaid, it is seen that the appellate authority has directed the competent authority to proceed in accordance with the provision of GMC Act. And accordingly, the additional commissioner, Guwahati Municipal Corporation, has issued the notice dated 15/11/2022. What is the period to reply notice?
Generally 7 days,
7 days.
but it is of 15/11/22.
Full stop. Full stop. However, admittedly, the petitioner has not yet replied to such notice. It is contended by the learned counsel for the petitioner that notice dated 15/11/2021 was received by him when the writ petition was moved. Therefore, he could not file and reply. Full stop. It is seen from the record that a notice has been issued to the petitioner to support his case. And it is also seen that the petitioner has approached the appellate authority without there being any cause of action, inasmuch as at that stage no decision was yet taken. Full stop. However, in the appellate authority has asked the Guwahati Municipal Corporation to act as per GMC Act. Full stop. This court do not find any infirmity in such order, nor it finds any infirmity in the notice dated first notice
House notice 26/9.
26/9/2022.
26/9/2022.
Inasmuch as the petitioner was given a chance by issuing such notice and no determination was made at this stage. In fact, no determination has been made till today. And the petitioner was given a notice on 15/11/2022. That being the position, this court cannot determine the factum of the present case involving whether the construction is illegal or the same can be regularized. Full stop. Therefore, in the considered opinion of this court, taking into in the principles of taking note of the principles of notorious justice, it is provided that the petitioner may reply to notice dated 15/11/2022 within a period of 7 days.
Can it be 15 days?
No, we
in
cannot
the
go
7
beyond.
days.
Then what is the statutory period? We cannot relate statutory period. Otherwise, it is already
It is already over. ma'am.
what is the
There
notice?
is no statutory, but in general, this notice comes with 7 days time.
Okay,
But
okay,
in the
within a
statute-
period of 10 days time to reply to such notice. And on the basis of such reply, the municipal authority shall be at liberty to act in accordance with the provision. If it is found that with the provision, full stop. Accordingly, with the opposite observation, the present writ petition stands disposed of without interfering with the determination made by the respondent.
Can there be some observation that if it can be compounded?
No, we are not saying anything. That is their subject.
Then till then, Lordship, the status quo.
Then it will definitely no deal with.
Maybe observed.
Till then,
Till the final order is passed,
Yes.
because in 3037.
no problem is that till the final order is passed, the status quo as on today shall be maintained. However, it is made clear that if the application is not made within 10 days, a reply is not filed within 10 days from today, the JMC authorities shall be at liberty to proceed with the matter ex parte.
Okay.
Same or something to be added?
I was not there in the first half. Lordship, I'm informed that your Lordship is inclined to set aside the impugned order.
Set aside the impugned order with a liberty where as per law, whatever you want.
That is always there. That is their right. Obliged.
But only thing I'd like to draw your Lordship's attention to is that, my lord, while setting aside the order, whether, my lord, the holiday scheme is applicable or not, those things your Lordship will not decide, because, my lord.
No, will not decide.
Yes, because that may have, my lord, very wide ramification nationwide.
National.
Your lordship may perhaps, my lord, say that since they have not availed the benefit that was sought to be given under the holiday scheme.
So where is the holiday scheme? Let us see.
Your lordship will find that at page
81.
107 is the, my lord, type copy of the holiday scheme. 107. The case of the petitioner is that since there is no fall in sales, therefore this is not applicable. That is their case, my lord. Now, your
That is
lordship,
their case.
my-
Basic case is that.
yes, ma'am.
That holiday scheme you cannot make applicable. 100 and
107, 107. Clause 4, 5, and 6, particularly clause 6 may be relevant, my lord. Performance of. Clause 6 is that, my lord, performance of such dealership would finally be reviewed after 3 months, and if the performance remains the same, less than 50% of the target, then the dealer will be given an option of going on holiday scheme. A letter is to be issued to the dealer giving him her an option to avail the holiday scheme, the time period for which shall be maximum 2 years. To avail the option of the holiday scheme, dealer is required to submit the request along with their action plan for review within 2 years so that they can take back their outlay. Now, my lord, their cases, my lord, based on this and clause 2, after the review, list of ROs selling less than 50% of the target to be prepared. Now, my lord, if your lordship comes to the impugn order, why I am submitting all this, my lord?
which
so that
which one? Which one?
the order which has been impugned in this
Where is that?
petition, that your lordship finds at page 119.
119.
This is in respect of, my lord, 2 retail outlets and SKO dealership. The relevant portion, your lordship, will read, my lord, at page 122. So there was attempt to, my lord, settle the matter amicably. There were several meetings. It did not fructify. Second paragraph. Personal hearing was also given to both Srimati Sunita Singh and Sri Prakash Singh on the date of last meeting, dated 21/5/2019, to resolve the dispute for operation reconstitution, but without any result. In view of the same, we request both Srimati Sunita Singh and Sri Prakash Singh to resolve the dispute within 6 months from the last meeting, that is 21/5/2019. In case the dispute is not resolved within stipulated 6 months period, we intend to put Mr. Sharma and Company Silcha and Mr. Sharma and Company Kaline on holiday scheme. So this part, my lord, they are not agreeing to, because, my lord, they say that it is not applicable. As then your lordship may kindly read further. As on date, we have not received any intimation from any of the parties, legal heirs, for an amicable solution after the last minutes of meeting held on 21/5/2019 at Silchar Divisional Office. In view of the same, and as indicated during the last minutes of meeting, we are compelled to suspend the sales and supplies of so and so. Then next paragraph, while the ESCO quota of Mr. Sharma and Company Silchar and Kaline district Kasar will be diverted to nearest ESCO agencies, you are requested to peacefully hand over the operations of the outlay. My lord, since they have not, my lord, agreed to the proposal of going for holiday listing, a holiday scheme, that's why, my lord, this action has been taken to suspend the sales. So your lordship may perhaps say that, my lord, since they have not agreed to it, and the holiday scheme according to them is not applicable.
No, meaning thereby that they are saying that if we do not, if there is an admittedly dispute, if we do not agree to resolve it, then also you are bound to make a supply. That is their,
yes,
their,
that they cannot say.
under why?
No, Lordship. First ground is holiday scheme is inapplicable to us. Lordship, we kindly take a look at page 116 because that is also the relevant clause. Page 113, sorry. Clause 16.
Yes.
In case the dealer is not willing to avail holiday scheme facility as offered by the corporation and it's and.
Where do you get that?
Sorry,
Yes.
Lordship, 113.
130.
113.
113, yes.
113. 113. Lordship, the holiday scheme is at page 107, the last page of it. Clause 16, Lordship has it? In Lordship, clause 16? May I read your Lordship?
Yes.
In case the dealer is not willing to avail the holiday scheme facility as offered by the corporation and continues low nil sales, show cause may be issued after 3 months of offer and action as deemed fit, including termination, will be taken by the corporation. So there's twin. You have, Lordship, the whole holiday scheme is based on the fact that we have low or nil sales.
No, where is your otherwise how can, suppose forget about there is no holiday scheme, there is no dispute.
Lordship,
Now,
Lordship.
under the license or contract, what is the mode of termination?
Lordship, there's an agreement and there's stipulated grounds of, Lordship, I'm obliged. There's a dealership agreement. There are stipulated grounds for termination. They have not gone to that.
So therefore, they can
No,
go.
Your Lordship, under the Essential Commodities Act and the order under it, they are obligated that there is an uninterrupted supply of petroleum products. So you can't just suddenly come and terminate a dealership. There is, in fact, Lordship, there
No,
is a
that is up to them. That is
My
suppose.
lord, I may just interfere, my lord. Even before termination, we have to give them a notice. my lord.
Notice. That's,
That
that is what.
we have not taken that action.
That
No,
they have
but
not.
Lordship, the impugn order says they're going to take back. It is-
Suspend.
No, Your Lordship.
They have not terminated your contract.
Lordship. Lordship, it's only take second last paragraph. Hand over outlets. It is termination. Lordship, kindly read the impugned order, page 122.
Hand over to us. If it is resolved, we'll hand it over back to you. Because we cannot stop supply. There should be uninterrupted supply,
sir.
but we do not want through you.
No, Lordship, they're terminating the dealership.
They have not
Yes, sir.
terminated. They said we suspend the dealership.
No, I'm challenging that they cannot there's
So
the ground for.
therefore, if you see, let us understand the scheme.
Yes, Lordship.
We have accepted for the time being that not only family dispute, but that family dispute must lead to fall in sale.
Obliged, Your Lordship.
Okay.
Obliged.
Fall into sale.
Obliged.
Only then they can put into holiday list.
Yes, Your Lordship.
Okay,
Because
fine.
then supplies
Fine.
get
Okay,
affected.
listen to us.
Yes, Your.
Holiday scheme.
Yes.
So your whole case is that the second condition, twin condition, second condition is not fulfilled. Therefore, we will not come under holiday list.
Lordship, not the second condition is there. Lordship, if you look at the scheme of the holiday scheme, it doesn't contemplate a holiday scheme unless Lordship may take a look at page
No, that
107.
is what I'm saying. Maybe there is first condition that there is some dispute amongst ourselves.
Lordship, there is non-performance of low sales and nil
That is
sales.
what. Let us complete the language sentence. Your case is that maybe there may be some family dispute, but sale, there is no effect on sale.
Yes.
Therefore, unless that condition is fulfilled, when it is twin condition is required in such a case, family dispute and drop in sale, you cannot put us in holiday list.
Obliged.
That is fine.
Obliged.
Fine. Now, at the same time, Essential Commodities Act says that there must be uninterrupted sale
Yes, Your Lordship.
of supply. That responsibility is put upon the oil company. Oil company. Now they can assert in such statutory obligation either through their dealers or they themselves. Okay, fine. Suppose we say that this is in view of the twin condition, prima facie, we are interfering it. What next? The next is to give them a liberty to proceed in accordance with the contract. If they want to terminate, you terminate them. That's all.
Yeah, no
That's
problem
all.
with that. If
That's
in
all.
law they are
But we
entitled to
cannot
terminate-
say that since there is an essential requirement of supply chain,
No, no,
a contract cannot be terminated. This will be too
No,
far-fetched.
I'm not making that submission. Absolutely, Your Lordship. If they can make out in law a ground to terminate, they may do so. The ground for termination in the impugned order is untenable, is our submission.
Mr. Chaudhary, apparently it seems that twin conditions is required, though your scheme is not properly drafted. But first part is, still you have a scope for interpretation. But in second part, it's difficult. First part, you say performance of retail outlet are to be reviewed every 6 months. Okay, after review, list of ROs selling less than 50% of grades, reason for it. Now, if we come to paragraph 4, if the reason of non-performance, low sales, nil sale is due to temporary financial problems or dispute among family members, partners, so and so, so and so, the dealer would be counseled by regional factory manager.
Dispute among family members.
That is also there. That is part of it. So, but it is relatable to you have made it relatable to the sale.
Yes. My lord, even my lord, assuming that
No,
to
we
be
are
correct-
saying that you can consider a price, but there is nothing to show that there is a decrease,
There is no
decline in
decrease.
sale.
There is
In
no
that,
doubt.
in that order.
No.
So you can still, open to you if you can show that there is, you can even opt for holiday scheme if twin conditions are fulfilled.
Yes, I agree, my lord. I agree to that. What I submit is that, my lord, here the issue is reconstitution. One of the legal heirs comes and says, look, you cannot debar me from being a partner. So if, my lord, there is a, my lord, guidelines for reconstitution, we have to go by the.
Yes, of course, of course.
And, my lord, there is an, my lord, action proposed, my lord, that has been laid
That
down.
you proceed with that.
Yes, my lord.
Then you proceed with that.
Right,
We are not debarring you from proceeding with any other FAD remediable, including reconstitution and any notification, anything you are authorized to do, proceed with that. That's all. Hard. Ms. G. Goswami, Learned Counsel for the petitioner. And Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. Burwa Bharadwaj, for the
Indian Oil Corporation.
Indian Oil Corporation. The present application under Article 226 of the Constitution of India is filed assailing an order letter dated 2011-2019. Yes, correct? 19, issued by the Chief Divisional Retail Sales Manager, IOCL, whereby in inter alia suspending the sale and supplies of the retail outlet and an SKU agency belonging to the petitioner. Full stop. The impugned communication, where is that page?
120.
119.
119. The impugned communication dated 2011-2019 reflects the following: that there has been a dispute between the legal heirs of the original distributor, namely
B and C.
let B and Singh, as regards their share in the firm. Full stop. Accordingly, for an amicable settlement, a meeting was held. And in the said meeting, a proposal was put that in the event there is no resolution of the settlements between the legal heirs of the said proprietor, the dealership of within bracket RO and SKO shall be put into holiday scheme. A period of 6 months was given for resolution of such dispute. From the aforesaid impugned order, it is also discernible that such meeting was held on 21/5/2019. However, no resolution was arrived at till when no resolution was arrived at during the 6 months. Accordingly, the sale and supplies to Messrs. Sharma and Company Co. Silsar Retail Outlet and SQ Agency Dealership and MS Sharma and Company Kaline within bracket, just see page 122. Retail Outlet SQ Agency Dealership was suspended with immediate effect. It was also decided that the supply of the quota will be diverted to the nearest SQ agencies, and accordingly, the petitioner was requested to peacefully hand over the operation of the outlets of MS Sharma and Company Silsar and Messrs. Sharma and Co. Kaline to Indian Oil Corporation Limited with all the assets therein. It was further asserted in the impugn order that such order was passed in line with the provision of clause Z within bracket 9 of MOP and NG reconstitution guidelines. Full stop. MS Goswami, learned counsel for the petitioner, referring to the holiday scheme, which is part of the record, page 107. Part of the records submits that a retail outlet or a proprietary firm can be put into put under holiday scheme only when twin conditions of fall in sale and fall in twin condition of on the condition of non-performance and fall in sale. Full stop. According to her, admittedly, the agencies were put under holiday scheme only for the reason of the dispute between the shareholders, and there was no allegation that there is either non-performance or fall in sale, and therefore the impugn order is liable to be interfered with. Full stop. Par contra, Mr. Chaudhary, learned senior counsel appearing the IOCL, submits that even if it is assumed that non-performance or nil sale is a condition for putting a agency / dealer under holiday scheme, the scheme, the Oil India will not be powerless to suspend the supplies when there is dispute among the partners affecting the business.
Legal years, my lord, legal years.
Between the legal years, affecting the business. Mr. Chaudhary further contends that there is already guideline and resolutions and notifications for reconstitution of dealership, and in terms of said notifications also, as the dispute has not been resolved, the Oil India will be within its competence to suspend or to cancel such dealership.
Not only the guidelines, my lord, according to the agreement also.
Guidelines. He further contends that, in fact, the agreement between the petitioner and the dealer also empowers the between the Oil India and the dealers, also empowers the Oil India to terminate such license by following the due procedure as prescribed under the guidelines as well as under the terms of the contract. Full stop. We have given anxious considerations to the arguments advanced by the learned counsel for the parties. From the reading of the holiday scheme dated 21/12/2016, it seems that the procedure of holiday scheme is laid for termination of dealer when performance of the retail outlet are found to be non-performing or non-performing for the reason of low sales / nil sales, for the reason of temporary financial problems or dispute among family members / partners after death of proprietor or partner, etc. And such performance, in terms of the scheme, such performance are to be reviewed after putting it under holiday scheme within 6 months. And if the performance remains the same, then the dealer is required to be counseled for next 3 months. And even if there is no improvement, the dealer can be suspended, terminated. Full stop. Full stop. Though issue has been raised as regarding the applicability of dispute, applicability of such holiday scheme to the dispute, relatable to a dispute among family members. However, in the case in hand, though there are apparently some disputes among the legal heirs of original dealer, the impugn order do not disclose anything about the sale or their performance. Full stop. Just will say performance. Though Mr. Chaudhary argues that performance cannot be isolated, cannot be a standalone event, even if the sale is there, for the reason that such dispute can lead to discontinuation of supply which is necessary, or if it is in the satisfaction of the oil will be IOCL. I will correct it. IOCL shall be within its jurisdiction. Without endeavoring to such arguments, it is seen from the impugn order that only reason for putting the dealers under holiday scheme is for the reason of dispute among the legal heirs, and there is nothing reflected as regards the performance of the dealership. That is admitted, nothing is there.
One sentence
Yes.
I'd like to add, my lord. The impugn order says about, my lord, clause G9.
That we are coming, that I am saying, that I are coming.
Lordship, I haven't argued on G9. I have a full-fledged argument that that itself is also not a ground to suspend supplies. Because that impinges on the trial court, and IOCL can't supplant itself to be the trial court and decide a dispute between heirs.
Full stop. In view of the aforesaid, no, but they say that this is in line with. They are not saying this is the reason. They are saying it is in line with.
Only, my lord, that line should be there because, my lord, so that it doesn't affect, my lord, other cases.
No, that we understand. Full stop. Full stop. Therefore, in that background, this court is also of the view that the impugn order is liable to be interfered. However, accordingly, same stance interfered. However, this court cannot be oblivious of the terms of contract and the other statutory provisions as between the IOCL and the dealer. So far, the same relates to termination and termination of the contract or suspension of supply in the given facts of the each case and the right of the IOCL. Full stop. Taking note of that, it is made clear that though the order dated 2019 is interfered, however, same shall not be treated as comment on any of the right and liabilities of the contesting party to act in accordance with the terms of the contract as well as statutory and other provisions under which the oil on oblique or the dealer may be entitled to protect their rights. Full stop. Accordingly, in the aforesaid terms, read. We are not saying, they let them consider. No, therefore we will say accordingly, the interim order passed earlier shall merge with the present order.
But the other case has been connected. I don't know, my lord, perhaps
Should we
because of this.
segregate that we are asking for a mandamus for reconstitution.
Which one?
6074.
60? Item number?
Item 5.
We have passed order in item number
4.
4. Item 5, this matter may be segregated from WPC 9468 of 2019.
There, my lord, I'd like to point out, my lord, the prayer there is that, my lord, the reconstitution should be made, leaving the, my lord, and my lord, that party is not there, my lord. He has not been made a party.
Find an impediment.
That is at
I'm
your
just
wish.
pointing out.
We are saying in that case that they have nothing to do, that land is only my land, Lordship, that is nothing to do with the ancestral property.
So if you make a name of somebody, if you know that somebody is having a claim, is it not your responsibility to make him a party?
Our position is they're not the necessary party. Because that is
Fine, very well. That is your
yes,
decision.
your lordship, yes,
We will decide.
yes, your
We'll
lordship, that is
decide.
my point. Let them file an
Be
impediment.
bold. If you say they are not necessary, they are not necessary.
They are not necessary parties.
We'll decide that.
Yes.
Observe IOC may
Yes, we have seen the recognize everything. We have
All
only
laws, every
interfered.
law.
We have interfered with the order dated impugn order 2019 to the extent it is not supported by the sale. Rest we have given they.
That is, my lord.
Lordship, that I have an argument,
G9, my lord,
full-fledged
I was
argument on that.
pointing out.
If Lordship goes into it,
That
then
we are not going to G9.
Yes.
G9 is a reconstitution and suspension.
party under holidays.
That is
says
also
in
provided
G9,
there.
It is provided.
then Lordship will have to hear me full-fledged because that is the crux of the matter. We say G9 is inapplicable.
Because of low sale and my lord.
Where is the G9? Tell us. We have since we have dictated how much time will it take.
Lordship,
5 minutes it will take. Give us.
let me place my order on G9.
Show us the policy of G9.
Yes. Lordship,
Because they were impugn says about that clause.
No, that it says we have in
270.
conformity. So they are not saying that we have passed this holiday list is not excluded by. Yes, where is the place that shows the G9?
270, your Lordship.
Huh?
270 Act 281.
270.
Paragraph 9.
Lordship, we first see page 281 because it is important. Process of reconstitution. 81. Yes, your clause 9. Lordship, this is for commission dealership. Clause 9. Dispute in case of induction of nominee, legal heir, family member amongst partners. Partners can transfer his or her shareholding in the dealership to a legal heir, family member outside, subject to adherence to applicable statutory provisions and the incoming partner meeting the eligibility criteria. So, Lordship, this is a dispute regarding to induction of a nominee, legal heir, family member amongst partners. So, first condition is there must be partners. There must be a dispute amongst partners.
No, this can't we read it like this? Dispute in case of induction of nominee.
Amongst partners. Lordship,
Listen. Dispute in case of nominee. Dispute in case of legal year. Dispute when dispute among family members of partners. Partners, isn't it?
Lordship, we read the whole thing.
Yes.
My submission is that is not what it is.
Mm.
This clause, Lordship, what is reconstitution? Today, as of now, the dealership is in the name of Sharma and Company. Who is Sharma and Company since the partition? It's SP Singh, one of the sons, who is the petitioner, the proprietor. So as far as IOCL is concerned, the dealership is Sharma and Company and Sharma and Company is SP Singh. So IOCL is not bothered by anything more than that. When there is,
So they are relying on this 9.
yes, Your Lordship.
Mr. Goel, if you want to go deep into this,
Lordship,
No, my lord.
you want to go deep into this,
No, my lord, what I submitted.
ask him. He's raised this question.
No,
I
my
can
lord,
go
my-
into
my-
right
my-
now. Right now I can go into this.
No, my lord.
He knows why he's not going into this.
I say that, my lord, this was reflected in the MP
You
note,
know,
but
that we have
this
reflected.
This may not be applicable, my lord, that your lordship may observe.
I have said that. He wants to go into, let me this is why it will take 5 minutes to answer. Want it? Tell us. Then all issues is resolved.
Thing or not multiple this holidays.
No, this is, you have argued that under this can be done under whether this is applicable or. Okay, let us argue. You argue. I have understood your case. Huh? Argue.
So, Lordship, my thing is.
No, I have argued. I'm happy with your argument. That's all. We'll dictate the order right now.
Your lordship.
No, we are dictating. Tell us. Want it?
No, my lord, what your lordship.
We are dictating that though it is written in dispute in case of induction of nominee, the clause itself says it is relatable to only partners only. Want it?
But
Lordship, kindly, I'm happy to argue it. And
Don't
satisfy the
invite
lordship.
trouble for your client. It's very clear. It's no need to interfere.
Lordship,
Why I
understand
said
the
it will
interpretation
take
and
5
finding.
minutes.
Lordship, then maybe
It
I
did
should
not
press.
take even 5 minutes. 2 minutes I took it.
Highly obliged.
Lordship, then we reflect that in the interim order, in the order.
Yes, point number 4.
Obliged, Your Lordship.
Highly obliged.
You have other remedies. Do that. Still order. And list of the list. When is to be listed? Other method 23.
Lordship,
Any
pleading blocks
urgency?
are not complete. There's, sir. They've not filed reply. They have not filed their impleadment.
No, today, my lord, I am pointing out that, my lord, there is a necessary party. That is what I am pointing.
Okay, we'll file it.
After puja vacation.
Their habit, my lord,
Oh, don't say all this. Whose habit which do not, we have not even,
making us party. Your
we have not seen the file. Don't you argue under legal constraint. What is their habit? Forget about that.
And they are saying
Mr. Goel, this is not the way to argue.
2015 also, your lordship. Filed without making us.
You are not a party to that petition. Don't argue. That's all. Reserve it to us.
Today, my lord, I submit that, my lord.
What we done today? That
my
is
lord,
what I am
okay.
asking. We are not
I am
asking who has
pointing-
done what.
My lord, so far as the, my lord, IOC is concerned, we pray for time to file affidavit.
Okay.
And we also, my lord, point out that, my lord, the
Okay.
necessary party has not been.
Mr. Likhiwa, that write it. Mr. M.K. Chaudhary, learned case senior counsel, submits that matter may be adjourned to enable the IOCL to file an affidavit in opposition. He further contends that the
All the
some
legal years are not before
all
the-
the legal years of the original dealer are not before this court,
they are
not made
before.
parties by the petitioner, and therefore
Which is a
on this
formal defect.
on this count alone, no relief can be granted in this petition. Full stop. So the said argument shall be considered on the next date of listing.
Obliged.
List this matter on
4 weeks, my lord.
4 weeks. List after 4 weeks.
Like if 2 weeks after that, we'll reply and
No,
then
make a mention on that issue.
Okay.
Let them file an affidavit first.
oblige the lordship.
Yes, job card, job card.
No affidavit has been filed, my lord, respondent number 3, my lord. File on, my lord, 26, 20.
Scheme has been cancelled.
Imaginary, it is not reflected in the MGNREGA Act, my lord. Only to ensure 100 days the job, my lord.
Now, suppose 100 days is not given, then what is the remedy?
As
You'll have
per
to-
Act, my lord, as per Act, my lord. Minimum 100 days, my lord,
No, no,
provide job, my lord.
understand. We know that there is a prescription that every job card holder should be given 100 days job.
Minimum.
Now
Otherwise,
there is
my
no
lord,
job, then
Then, my lord, unemployment allowance, my lord,
that is
section 7,
section 7. Yes, what you say? You make a statement.
an allowance, my lord, provided.
That's it. Earlier video was transferred, so new video was joined. We communicate with the video. So need,
All this story we are listening every day. All this story
Calculation of the Act, my lord.
will it's an act of parliament. It mandates that 100 days work should be given to a only thing we'll have to see whether these persons are having job card. Number one, and whether 100 days job has been granted during this period. If not provided, then you will have to pay unemployment allowance as prescribed under the act and the rules. And above all, for delaying this process, interest which will be paid by the BDO from his own pocket. As simple as that. When? Tell us. We'll adjourn it. Interest at the rate of 9%.
it's a kindly 2 weeks maybe.
2 weeks, but these 2 weeks will be with 9% interest by the BDO. I will remember it. No, I'm not. A last chance is granted. An affidavit has been filed.
My lord, respondent number 6, my lord.
Yeah.
Video.
BDO file.
Stating that, my lord, 24 scheme already cancelled by the.
Oh,
commission
forget
under
about that
respondent number 3.
cancel. Cancel is not the.
Is admitted, my lord, no work provided.
No work provided.
My lord.
Let us dictate the order
Let's say,
with interest.
let's say BDO filed affidavit on behalf of the deceased.
So, any difficulty?
So we'll.
What is the statement, Mr. Padgiri, that your job holders admitted?
Admitted, my lord.
Which paragraph?
Paragraph number 4, my lord.
And
Of the
is it
affidavit.
admitted that 100 days jobs were not given to you?
My lord.
Where is that?
But, paragraph number 4, my lord.
Yes. Next Thursday, have instruction. And we'll have to argue on law, whether this is a right, and if it is a statutory right, how it is to be fulfilled. That's all. That statements are there. Are you getting anything?
But let's say.
Or everything is going above your head? Yes, tell us.
We have received some telephonic instructions.
What instruction?
In 2023-24 financial year, only 2 schemes were sanctioned.
Oh,
For the said.
is NREGA, na?
That's it.
NREGA is dependent upon scheme.
That's it.
What the act says, suppose there is no scheme, we can presume that in this area no scheme is there. The job card holders are having a card. What is the meaning of giving a card? Then what will be the provision under the law? Suppose there is no work. This job card holders are sitting idle. What will be then remedy? What? What the act says?
Section 7, X says that if an applicable for employment under the scheme is not provided such employment within 15 days of receipt of his application, seeking employment or from the date on which the employment has been sought in the case of an advance application, whichever is later, he shall be entitled to a daily unemployment allowance in accordance with this section.
You made statement that you have filed application. Statement said that.
Submitted application, my lord.
What is their stand on this affidavit?
Nothing stated, my lord.
Day after tomorrow,
That's a kindly 1 week maybe done.
next Tuesday. On the prayer of the learned counsel for the respondent, please this matter on 10th. We come prepared with the provision of law. Both the cases, na, 10 and 11.
Kindly accommodate the matter, but senior is in another court for the time being.
No accommodation today. On the prayer of the, what happened to this?
My lord,
And where is the insurance?
My lord, may I interpret your
This is
lordship, my
item
lord?
number who is,
11, your lordship.
Huh?
11.
okay, 11. PF dues.
Yes,
Yes, ma'am.
On the
May
prayer
I-
of the learned counsel for the petitioner, matter stands adjourned and be listed.
Today itself.
No, not today, not possible.
Any date.
Give
Yes,
the
no,
date.
my lord, may I interfere, my lord? The by the order
Yes,
dated, my
after,
lord,
mm,
80,
list after 2 weeks. Yes.
16 to 23, my lord, the petition was directed to deposit an amount of
So they
rupees
have said
30 lakhs, my lord.
30%.
Yes, your lordship.
You are free to do it, act against them.
But if you
There
are
is no stay order.
I'll
Not
have to
deposited, my
your
lord.
lordship, on the
Huh?
additional affidavit.
The 30
30 lakhs they have not paid, your lordship.
not paid. That is
Not
the
paid.
issue.
And there is an order by this honorable court where if not subject to interim order will be vacated if 30 lakhs is not paid, your lordship. This is the instruction, your lordship. I'll have to place. If I'm allowed.
Till now, they have not deposited, my lord.
On the additional affidavit.
This is a violation of this
Who's
course
your
of the
senior?
Mr. Zittumani Kolita.
After all, this is about PF contribution, my lord. This
What is Bharatmala?
There is a scheme, your lordship.
What is under which what will be done?
They will be able to apprise your lordship about the scheme, your lordship. They have only stated in the additional affidavit.
After some time. Yes, next
After
case.
obliged to, lord.
Yeah, or otherwise tell your senior that we'll vacate the stay order. Inform him that we'll vacate the stay order. Item? Yes. They say you take back the vehicle. Vehicle is not sold out.
Lordship,
Still with you.
lord, it's still with them.
Still with you.
It's lying in the workshop. They are in the Toyota's workshop.
You have been paid how much? 21 lakhs.
21.
Examine.
Lordship, my submission is in twofold, lordship. First thing that
He has challenged the ombudsman order.
ombudsman does not have the jurisdiction to entertain this claim, first thing, lordship. First thing, lordship, a claim has either to be rejected or there has to be representation. No representation has been made.
I've seen that.
Within 1 month, lordship, they reapproached the honorable ombudsman, leaving no margin to the insurance company to give it. Insurance company, in fact, lordship, had agreed to a total loss. And they are looking for auction buyers because the more the delay in settlement, the value of the year would come. So they are so prompt. Within 15 days, they decided they arranged for a meeting with the petitioner. It can't be faster than that, lordship. They appointed surveyor. Within 15 days, they arranged for a meeting. It was told that we are giving a total loss. Then, presuming that it will be a total loss, they went for an auction, not auction exactly, looking for buyers. Then who will buy this? Then they said that then buyers also put their condition. Within 15 days, you have to take this, otherwise value would come down. They would not agree to the original value, which is a loss of on 19th, on 1 month and they sent a letter to the claimant that this is what has happened. And that letter was duly sent proof of having sent that letter also. Lordship, this is one area, lordship, under rule 14(3)(a).
This matter requires some adjudication regarding
Yes, lordship.
the power and competence of
Yes,
the
yes, lord.
ombudsman in the manner the order has been passed.
Yes, lord.
That deliberation will require. Isn't it? Why don't you settle in the meantime?
When
You are
willing
in
to
the
pay the
hope of,
total loss.
something you would have gotten this.
Friday. And this letter, what has been stated, that was not sent to us. That I have not received. They may have sent it, but that was not received by us. But thereafter, that is not.
Is there any scope beyond the ombudsman? See, he has also suffered. We want you also should not suffer. Now, is there any scope for
No, Lordship,
settlement at this
we
stage?
think we'll stand by the same thing, we'll offer the total loss, take the vehicle. That is the maximum payable under the policy.
And what do you want? You want the vehicle to end up total?
No, Lordship, we are asking for the total loss, but in an enhanced amount, because the IDV was not fixed properly. There is a
That
calculation
is-
formula is there.
Lordship,
It is
after
their
10
formula,
months,
their
they can't
website. that
complain
is
about the
there.
IDV lots. After 10 months of the policy, they
That
can
is there,
complain about
Lordship.
that.
There was a lacuna on the part.
Okay, we'll hear it some other day.
Lordship, a short date may be given because every day the interest is increasing on me because it was a fine.
Let you understand, but this will require some hearing, not at 3:15 today.
Next week, any date.
Next week, not possible. Too many matters we fix. Yes, Muslim. First, we'll hear his matter. Then we'll understand what is what. Then if ombudsman is having a right, matter ends there. Then if he's not having right, then what next?
Yes, Lordship.
This is the issue. His petition is important to be decided. Because you are in support of that order
Yes, Lordship.
and he is challenging that order.
Challenging that
Your
order on particular law points.
law point. So that law point, if it is decided against him, then some could different course of action. If it is allowed, then some different course of and when Muslim? 19th of September.
Problem.
Lordship, after repeated orders, also my lord, two orders, file the affidavit, my lord. I have seen two WT messages for swearing, my lord, has been sent from our office, my lord, from 28th of August and 21st of June, 21st of June, my lord. So may I pay for a last tranche, my lord? That's
Okay. It is submitted by Mr. MSU Das Learned Council that affidavit is ready, and though it was intimated
to the district commissioner.
to the district commissioner to
Yes,
come and
Sergeant.
swear the affidavit.
My lord.
However, due to some occupation, the district commissioner could not come. Accordingly, she pressed for a last chance to file the affidavit. Prayer is allowed. List this matter on 23rd of September 2020.
Deeply obliged. my lord.
Affidavit be filed before that. date.
My lord. I'll try, my lord, because I have seen two letters, my lord, but not.
And you know what is the next course of action?
Lordship, I understand, my lord.
We will give chance to a
Otherwise, your lordship has given charge.
Yes, fire ex gratia. You said that money is ready or something like that.
But because of financial lapse, my lord, again, revalidation has been done, my lord, and it has been, so however, the sanction of an amount of 95,100 has been accorded by cancelling earlier all sanction order in current financial year up to 24-25 on receipt of the budget allocation for the purpose and fund transferred to the bank account of the petitioner under process, sent to the treasury on 16/8/2024. This is the instruction.
of the client, we have already this.
It is submitted by, you have wasted time. It is submitted by the Learned Council for the petitioner that the ex gratia claim has already been received by the petitioner. Therefore, nothing survives in the writ petition to be adjudicated. Accordingly, writ petition stands dismissed. Closed.
May I please, your lordship?
Yes.
Kindly peruse the last order.
Admitted the claim of the petitioner.
The matter is supposed to be listed for September.
Oh, 9th of September. Full stop. Though by order dated 29/8/2024, the matter was rejected to be listed on 9th of September 2024. However, registry has listed this matter today. Full stop. List this matter on 9/9 as fixed.
Next.
Yes, what you say, Kolita?
Lordship, you have filed an additional affidavit regarding lordship the order dated so and so to direct this petitioner to pay 30 lakhs.
We cannot stress anymore. What you say?
Yes, lordship, this petitioner is always ready to pay lordship, but because of lordship,
some financial condition that is going on in the company. So lordship, they are now handicapped lordship to just to pay the amount. So lordship, already in the additional affidavit, they have stated that they are ready to pay. Lordship may accommodate 2 months time minimum lordship. Then lordship will. Additional affidavit also we have mentioned lordship or lordship may.
So we'll say one thing, okay, we are giving you a chance 2 months, we'll fix the matter after 2 months.
Lordship, by the time.
We'll record your statement and with an observation will say that if it is not paid within this date, its stay stands vacated, they will be entitled to proceed in accordance with law.
No, probably, my lord, I didn't do any interim order, my lord.
Since he's seeking 60 days, let have a last chance, last hope. These are properties close to their heart.
Observation lordship, the calculation they have made lordship is incorrect lordship, and in additional affidavit lordship we have specifically mentioned how much.
Calculation is difficult. According to you, what is the amount?
It will come lordship around 2 crore 3,24,000. And as per dear lordship, it was 4 crore something. And by the time lordship, we have paid 1 crore 9 lakhs rupees we have paid.
So these are interest and all. What is the remedy? These are the interest. This
If
is
your
the
lordship produces the
That impugn order
Later
itself is lordship wrong lordship.
if
calculation
your
is
lordship
wrong.
produces
So what
later
is
the
your remedy to
second of-
determine? Who will determine all this?
Therefore lordship, I am saying that if they
No,
get
no.
me an
Please
application
tell us.
lordship,
If you dispute that this amount is not properly calculated, what is the forum?
forum lordship, but the party can amicably settle the issue lordship if genuinely lordship it is wrong.
No, you raise this, but we are not
They have
making.
they have raised an issue in the additional.
That
affidavit
way, my lord,
that
they will have to
that
approach the
doesn't apply
authority
to
of
us, your
concern, my lord, by filing a return petition.
Yes, we are not going.
Authorities had
We are
come
not-
here.
we are not going. We are simply saying that this was the interim order. You were supposed to pay 30 lakhs.
No, most probably,
Have
sir,
not
sorry, my
been
lord, I'm
able to
intervening, my
pay
lord.
it. However, he submits that he will pay within 2 months. They will be able to pay. So they will pay within 2 months.
Total amount is about 8.5 crores, your lordship.
Wrong calculation. They have to reassess because and to reissue lordship notice. Reissue notice they cannot claim.
Mr. J. Kalita, learned counsel for the petitioner, submits that pursuant to order dated 28/7/2023, the petitioner had already deposited an amount of rupees 50 lakhs.
50 lakhs.
50 lakhs on 9/8/2023. Full stop. However, this court, under its order dated 16/8/2023, petitioners was further directed to deposit another amount of 30 lakhs by 14/9/2023. And it was provided that the interim order is already gone.
Yes, your lord.
Interim order passed earlier shall continue till the next date fixed, subject to deposit of amount of rupees 30 lakhs, that is by 14/9/2023. Full stop.
Lordship or last order also mentioned.
However, on the prayer of Mr. Kalita, the matter was adjourned on last two occasions. Full stop. Today, Mr. Kalita submits that due to precarious financial conditions, they have not been able to deposit rupees 30 lakhs in terms of this court's order dated 16/8/2023. Full stop. However, they will be able to pay the amount within a period of 2 months from today.
Your lordship, they also not even deposited the employees' PF dues, your lordship. It is more than 3 crores.
Why are you sticking to this guardian?
Already
Let
collected.
it go.
Already lordship government has acquired some portion of land.
In the meantime, not will only go down your workers, everybody, and all this wastage of money paying to them.
Except this we have other
Overall,
benefit.
there will be law and order situation, my lord.
Other benefit they are ready to pay.
What other benefit?
Like
This is statutory benefit.
Accommodation, ration.
Okay, be that as you are not saying anything, be that as it may. Matter stands, already there is no
Yes, your
interim,
lord.
it is clarified. We have also not extended the interim
No,
order.
your lord.
Okay. First, be that as it may, matter stands adjourned and be listed after 2 months. We are saying nothing. You do whatever you want. Interim order is not there, not extended.
Can we have a fixed date, your lordship, after 2
Give a
months?
fixed date. List this matter on. 11th of November.
Anytime Lordship will pay this.
Oblige your lordship.
We do not know. You have now our hands are off. We are not extended the interim order. Now it's up to them.
We were instructed to apprise your lordship regarding the whole amount, even the PF dues, your lordship, employees PF dues, 3.5 crores,
You just next time we will just be ready with this.
which is already with them, your lordship. Oblige. Oblige your lordship.
Mr. N.C. Das, learned senior counsel,
Alright, phone numbers 2, 3 and
partially present, assisted by Mr. A. Das for respondent number 2, 3, and 4.
Oblige your lordship.
Yes. What is this? Hearing? Some instruction, something was yes. Report is there?
Sir, my lord, inquiry is to be conducted, my lord, but.
Conducted. Okay, Ms. MS UDAS learned council 6 for further 2 weeks time,
4 weeks, maybe.
4 weeks,
That's
4
what-
weeks time to complete the inquiry as
Okay.
recorded, as directed by this court under its order dated 13/6/2024
No.
and to produce the
Thank you.
report. Full
My-
stop. Prayer stands allowed, list this matter accordingly on.
After 4 weeks?
Give a date. Or you don't have also any.
No, there's some urgency in the matter because it's a long pending matter.
Give a date.
Lot. 4 weeks. First part of October.
22nd of October.
Oblige.
Please, your lordship.
What is to be done? How to protect your rights?
As per the provisions of the law, the government is liable, my lord, because for the police act, I have lost 4,10,000. Because they are the.
No, your only anxiety is that say you cannot prove the check.
Yes, my lord, I cannot prove the check.
So we'll make it clarify that there is a mention of this check. There is no dispute.
My lord, we have stated because FSL report, inspector also come in the court. my lord.
Everything has come, so.
But
so
but
the
this says without original, we cannot say anything.
No, we'll clarify that the validity of the check will be, shall
My
be
lord,
based on the.
if your lordship clarify also, my lord, the bank will take the other stand, my lord. Because they says they are insisting on the check.
Yes.
Lordship, kindly,
They will
also
insist on the
for-
check, my lord.
2 or 3 minutes, Lordship. My senior is coming.
Who is your senior?
P. Goswami.
Additional AG will appear.
Education appearing on whose behalf state?
Yes, Lord. He's coming, Lordship.
Mr. Das, you are appearing for whom?
For the pro forma, my lord.
Huh?
Bank, my lord.
Precarious situation.
Yes, my lord. Whether the DD's Boshu's case is clear, my lord, the strict liability will be liable on the state, my lord, for their negligence.
Whose negligence? We'll have to first
That
have
is,
the
that is the
satisfaction.
state. The police has admitted, my lord, that they're missing from the police station.
Who is that?
They have given the affidavit, my lord, in the report also, by the judicial
places.
officer.
Yes, Goswami, what to say?
In
Precarious
fact, my lord,
situation.
police has filed affidavit here, my lord. And it is abundantly clear, my lord. The petitioner also obtained certified copy of the, my lord, the FSL report as well as the, my lord, check, my lord, from the office of the Chief Judicial Magistrate, Kamrup, my lord. So that is why, my lord, there is
What is
no
your
point of
stand? According to him, where it was misplaced?
that part,
Any stand
difficult
in
to,
the affidavit?
my lord, that part it is difficult to say, my lord.
Therefore, I am saying, see, okay, we can accept if it is a case,
Right.
because this case needs some deliberation.
Right.
Why I'm saying is, first, your case is projected in a way that acquittal was against the bank officers, admittedly bank officers, but other person remain absconder. So he can still be tried. That is a different issue. The judiciary said that no, we have not received the check. The police say we have given the check.
Because, my lord, search sheet was submitted.
Understand? But along with the search sheet, you must
Yes.
please give a list.
Yes, yes.
Where is that? Okay, where is the case then?
Just as one point, my lord, the affidavit given by the police, he himself had admitted that while shifting the police station, the check was missing.
If that be so, then
That is,
That is-
wait.
Yeah. What I'm just giving. you.
Inquiry report is there.
That is the case,
That's
my lord.
Punil.
It is himself admitted, my lord. The concern of.
But is that then clear? Mr. Goswami?
I have not seen this. My lord.
So,
Because after
Mr. Goswami, does assist us because see.
Certainly, my lord, because no point of keeping it my lord,
Huh.
pending and my lord.
Two issues. Apparently, he filed a case for against the bank, saying that this is your negligence. You have
No
the
grievance
forensic
against the, no grievance against the police.
no, the forensic says that this is not the sake, and you have cleared it without even after overwriting.
Yes.
So it is a criminal is a different thing. So he wants his money to be returned back. Now his whole predicament is that there is no sake to exhibit. That this is the sake to exhibit. But forensics report is yes, we can make an observation saying that yes, forensics report is this sake is admitted. What more is required by the consumer forum? It can be rely on decision whether there is negligence or not on the basis of that. This is one aspect. He is insisting sake we cannot find it out today. We'll have to call the God.
Yes.
Isn't it?
Yes.
We cannot. So if we cannot, then what is the way out? Other way out is he is arguing that since it is the admittedly fault of the police, please state give us the money. For sake amount of the sake with interest.
Malkhana, it was
No.
it was misplaced somewhere at Malkhana. Malkhana is
Malkhana is police station.
well,
Police,
during
under
the
police.
time they transferred the PS building from so.
This is report, inquiry report.
Where's
Part of what?
Pursuant to the order dated.
That inquiry report is given to the state.
Yes, Lord.
It is in the record there.
Okay, not today. Just go through it. Highlight it.
Can it be a part heard, my lord? Because your lordship has heard it, because it's a matter of 14, my lord.
I have too many part hearts.
My lord, I'll be obliged, my lord, because.
Too many part hearts. And
Because your lordship has already
easily
the
concede. I easily concede to the request of the council. Therefore, longest part heard list.
The lordship is always the domain of this case, my lord. That's why.
No, we'll hear it. We'll hear it. I'll be here.
They will furnish a copy. To me, my lord.
Yes, who will furnish a copy?
That,
Copy of the inquiry report submitted by the District and Session Judge Kamrup Metro dated 7/6/2017 pursuant to discourse order dated 24/4/2007 be furnished to Mr. B. Goswami, learned additional senior government
Additional
advocate, additional advocate general by the petitioner. Are you having a copy?
Yes, I had a copy.
By the petitioner. List this matter on.
My lord, come after 2 or 3 weeks because my lord, I'll send it to the police concerned, my lord, and they will have to reply, my lord.
19th. 1st of October.
First of all.
1st of October. My lord, I'll be, my lord, first. My lord,
That should be part of record because it is written to the register judicial. Is it not a part of record?
because 1st October, my lord,
It will be part of record. Already on record. Therefore, this
can
is a
it be on
Xerox
the
copy. I'm
30th,
still,
30th of September. Because
30th will be difficult. 30th will be difficult. Your
first October will be-
your object of it being heard by me will not be
okay,
fulfilled.
okay, your lordship, 1st October.
And it should come showing my name, my lord.
Okay, registry to list this matter reflecting name of Mr. B. Goswami, learned additional advocate. Mr. Goswami, you are giving money everywhere, fire victim, accident victim, everywhere. So he is also a victim.
I'll be obliged.
But someone has taken the money, my lord.
Yes. But state has failed to protect his money.
That part also it is difficult to say because my lord, otherwise, my lord, no point of keeping this sake with the police, my lord. How the purpose of.
No,
what
no,
is the
that's not.
purpose,
So
my lord?
therefore, think on that line
Yes,
also.
that is why, my lord.
He's
I'll
arguing.
talk to them, my lord.
Yes.
Why it is written.
Yes, Ganguly.
No, this police firing case, my lord, in which.
Oh, that. Yes, Admitted. He is a witness. He is a witness, pay him. He is not an accused. He is not an accused, he is a witness.
That has been my stand from day one, that I was injured, then they refused to admit from day one. And in fact, I was taken by policemen to hospital in
Where is the
case-
scheme?
Lordship.
That payment of this will your case come under that firing on that is only your extremist?
No, that, yes, that is only an.
There was a police firing, a person is injured. He, for no fault of him, he is a witness to the case. Well, you come and be a witness, pay him the money. What is the otherwise amount under the scheme? That extremist scheme, injury. That's are you having that? To understand the what should be. More or less, we are of the opinion that in the given facts of this case, there was an unruly mob.
Unruly mob. Yes,
Unruly mob to disperse that there was a fire. According to petitioner, he was a bystander standing on that. He got injury. Up to his injury, there is no dispute. Now, initially, we had a mind that whether you may be part of this unruly group, so why should the state compensate you? Then we found that he is not neither a named accused nor he is a substitute accused. Rather, he is a witness. So, if he is a witness, give him money.
Yes, hospital was free.
It was,
Yes,
we have,
Maybe free, but
it is done by free, Lordship.
free, we understand. His treatment is free, but a person is injured.
That state will,
That is what I am saying. Have you filed affidavit?
yes.
What is your stand that we have treated
That we
free
have
of cost?
treated him as per policy of our hospital policy, we have treated.
They have treated me only there because the policeman has taken me there. Otherwise, they would have not, because as your lordship knows, civilians are not readily.
Anyway, police also knew that you are not
Police
there.
got me to go, GMC also, man. And later they made the turnaround saying, no, we don't know who has done this. Our stand was that if there has been firing,
According to you, what should be the compensation?
but what can be done is that because this is a writ proceeding, my lord, perhaps lordship may the amount which as per the notification.
That's why I'm
The
asking.
latest
See,
notification.
latest notifications at par.
Lordship.
Extremist killing or getting injured, how
Should
much
be-
they are paying.
Right,
We'll
my
go
lord.
to that standard. We'll not decide.
Lordship. And my lord, in fact, in my humble submission, my lord, this should be at a level at par of extremists because here the state, my lord, has fired. And this is a case of.
But the state has not fired as an extremist to protect the unruly move. It was an accident. But of course,
You
there
cannot
you
win
might
this.
be liable to, they might liable to pay you compensation.
What can be done is perhaps.
When?
Tuesday.
or my lord.
You have, you collect,
I'll bring
you-
the latest one and
you-
if
you
possible, I'll
bring-
bring some precedent also. my lord.
you precedent some.
No.
Okay, as agreed to by the learned counsel for the parties, list this matter on after 10 days. 25th.
What should be?
List is very long. What is this, Mr. Fukan? Yes.
My lord, this is we terminated the contract, my lord.
Ah.
And also recovered some money, my lord.
Now,
And
then
Subsequently
So-
terminated my contract also.
now what is the issue here?
issue, my lord, they're selling the termination as well, my lord, there's
There
some
was one
recovery.
demand in terms of which I have come to court, a protection was granted. Some after that, the entire money was exhausted and taken away from a different contract because they said that contract allows them to do it. Subsequent to that, within a span of 10 days, by giving me notice that, you have to complete it in 15 days, they terminate my contract also. My extensions have all been approved by NF Railway. During the period of extension only, they have done that. So my case is that, I have suffered for this. I was ready to complete it. 9 years they're saying it's not being done. It was just not my fault. Land was never given to me. Money was not sanctioned.
No,
When the
first
extension was
part is
extended-
that they have set up some amount.
Correct. That's the first case.
The first case we have delivered some judgment that if you cannot do unilaterally.
my lord,
If you cannot do unilaterally, you can go through
No
it.
hearing, nothing.
You can do it through the adjudicated mechanism and so pay the amount within 1 month, if not with interest. That part we have already delivered a judgment day before yesterday. It is still in the correction stage. That relates to
I'll check.
FCI.
I'll check it. I'm not aware of
I'll
it. I'll
check,
check
my
it
lord,
definitely.
so this.
And we also follow the judgment of the division bench, single bench, division bench that went up to Supreme Court. Supreme Court says, yes, they can claim it, but it should be through an adjudicatory process. That adjudicatory process is the given, which is given in under the contract.
Contract.
So you cannot unilaterally do this. So that part, one part is answered. Then what is the other part?
Termination.
Termination may be difficult.
Because my termination happened when during the period of extension. The extension letter was given to me when the extension period still
Extension
remained.
given by whom?
Railway.
And who is he?
I'm really, my lord, this is after 9 years, my lord, 9 years, my lord, and extension, my lord.
Extension was up to which date?
My lord, it is up to, my lord.
I tell you, Lordships, what happened. 2013 contract. 1 year, they said, please hold on with the contract because they were having some financial problem. 2014, they say you can now start the contract. 2014 till 2022, there was extensions which was granted. I applied for the extension. All reasons were explained in the extension and extension granted. 2022, the extension finished. The railway writes a letter to me. Please apply for an extension and complete the work. I apply. When during that period when the extension was to be given to me, they first issue me a demand. With no background, I come to know with the demand notice that there is a vigilance inquiry behind my back. They said they are entitled to, I am entitled to pay them money of 3 crores. Everything happens behind my back. In terms of that, I come to the High Court. High Court protects me.
Now what is that IA?
IA was, my lord,
on the last occasion, said will be heard in
my
final.
IA was only for, there is interim order, my lord, for taking interim order, this, but
can be
finally,
heard
there is the
together
order, my lord, to hard matter finally, my lord.
What is the urgency?
Yes, my lord. On 26, my lord, this we propose, my lord, because today I have some submission also, my lord.
22 meter. We generally don't give preference to 22 meters.
Because only termination, because
But the only thing is, I was requesting him because this has been, I mean, in and out for a long time. I just wanted
because, my
that
lord,
should be
what
heard.
happened, my
That's all.
lord, so for termination of contract, my lord, because the pending case, my lord, there is no press standard, my lord, initially it was issued, but subsequently withdrawn pending of the case, my lord. This railway, my lord, this Jogi Park, my lord, this regarding the bond of this land, my lord.
You have created the problem.
Absolutely.
Not, my lord, this I'll explain, my lord.
Okay, when will you explain? Tell us.
My lord, on 26, my lord.
I do not know. She will say, I do not think now we'll get a date before October.
Then, my lord, immediately after vacation, my
He'll
lord.
be happy, he is unhappy.
No, I also not, because
I'm only
this
saying let
termination
it be
so
on 26th. If it doesn't happen, I'll keep it to faith, but you know, then we will see what happens on 26th.
26. Okay.
If
She's
it's
saying-
not inconvenience to your lordship,
Okay,
that's all.
let's this matter on 26.
both the cases, my lord.
What are cases?
And only yesterday case, my lord, if I, my lord, then we will go through this judgment of this honorable court also, my lord.
That not yet uploaded.
Yes, my lord.
We'll keep a track on that.
I think this will be uploaded today. This is basically FCI handling contract.
Name of the
The
parties?
contract says that you have a right to set off from any other contract that is entered between
Correct.
FCI
Similar
and
contracts,
other
similar
contract.
contracts.
So on that basis of that, they set off and said that you and the money entitled in X contract now is will be recovered.
Similar situation.
So we said you cannot do that.
Similar situation.
Different, my lord. Here only, my lord, is,
You,
my
you-
lord,
you cannot do that
No, my lord.
without notice, without anything,
Absolutely. That
and
is my case.
that you can do only after an adjudicatory mechanism.
My case.
Earlier, a single judge held that went to division bench. Division bench said, okay, single judge straight away allowed. Division bench said on the same contract, let's see, okay, we have upheld the judgment of the single judge since it's a public money. You will have a right to adopt the legal course of action.
Correct.
Then the FCI went to Supreme Court. Supreme Court clarified nothing doing, will not touch it. But the adjudicatory mechanism, we clarified that shall be as described in the contract itself. That's all.
The only reason why they are saying that it is not applicable is, lordship, there is something called an expected matters. When I say, because they have been in the counter, they have said this is an arbitrable issue. I say that
No,
my
but
termination doesn't fall under arbitration. Therefore, that
there is
invoking
not
of that
there.
arbitration is
So
not
therefore,
available.
claim of money, recovery of money in respect of other contracts arising out of another contract, we
Yes.
have interpreted.
Here, here, my
all
lord,
the
here,
cases.
here, my lord, here, my lord, we,
I'm
from
similarly
the same
situated.
contract.
What is
my
the name of the parties? Some T State versus FCI.
lord. Yesterday,
Huh? Not Lido. Case that SC Barbara. I have corrected this order today only. I think it will be uploaded.
yesterday's case, man.
Not yesterday's. It will around 28. Huh?
We'll check it.
We'll
get it.
Some T State. It's a handling contract under FCI.
East. It will be reported also.
No, not Lido is something different. Anyway.
26.
26.
We'll try a lot.
Yeah, while because something is there in our case, man.
You can have it from Mr. Barbara.
Borgo
But
High,
today it will be uploaded today, I think. Na?
SC Barbara.
SC Barbara. Or Barbara.
Or Bobra. I will.
Great.
Ale.
Barbara, huh? Yes, Pathak.
You already recorded my submission. I just wanted to add a few
That's
small
why
points.
we'll record that. On a lighter sense, on a Friday mode. Yes.
So I will just to Lordship, I already recorded
Yeah.
most of what I've given in my written arguments. I am relying on sections 47.
Why we are doing it is day by day is because moment we make it a CAV, huge evidence and all, it will take months to complete. So we are slowly doing our chambers of here only.
Yes. This way it will be quicker also, Your Lordship.
And everybody will know who has argued what and what we have recorded.
I am relying on sections.
In suppose, yes.
I am relying on sections 45 and 47 of the Evidence Act, Your Lordship. 47, Your Lordship, is when is an opinion as to handwriting relevant, Your Lordship. It says, when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is a relevant fact. And the explanation is, a person is said to be acquainted with the handwriting of another person when he has seen that person write, or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business, documents purporting to be written by that person have been habitually submitted to him. Here, no evidence was led by any person that the handwriting in those specimen forms was actually of the person's.
Just listen. Referring to section 47 of the Indian Evidence Act, Mr. Pathak Lanes Amicus argues that there was no iota of evidence on record to suggest what?
Suggest that the accused persons are the ones who have given their that the
To
handwriting
suggest that the accused persons are those who had
put their signatures in the specimen forms.
put their signature in the specimen form.
Then, Lordship, section 45 of the Evidence Act allows a court to rely on the opinion of an handwriting expert. But the law laid down by the Honorable Apex Court is that those such, because handwriting is not an exact science. So when such opinion is relied upon, then there must not be any doubt as to the specimens, Your Lordship. So last time I had given the citations, if I may just read.
Referring to the determination made by the Honorable Apex Court in
The judgments are, I had already given those last time, Your Lordship.
Uh,
Sheila Sebastian versus R. Jawahar Raj
Sheila Sebastian.
versus R. Jawahar Raj, 2018 7 SCC and 581. And State of Maharashtra versus Sukhdev Singh, 1992 3 SCC 700.
751. Mr. Pathak argues that. What will you argue? Pathak argues that.
Firstly, Your Lordship may have State of Maharashtra versus Sukhdev Singh, paragraph number 28.
Argues that. Paragraph 28, na?
28, Your Lordship. The first line, Your Lordship, while the rest of it is facts, but the first line is a pronouncement on law. Before a court can act on the opinion evidence of a handwriting expert, two things must be proved beyond any manner of doubt, Your Lordship. The standard is any manner of doubt, namely the genuineness of the specimen stroke admitted
Argues that the genuineness of the specimen / admitted handwriting of the accused is not established beyond doubt in the present case.
And paragraph number 29, Your
And
Lordship.
therefore, according to Mr. Pathak, the evidence of the handwriting expert, that is PW,
PW
37 and 46 cannot be treated as reliable and dependable witness to convict the appellant in the given facts of the present case in absence of any other cogent and convincing evidence so far relating to their handwriting.
PW 37 and 40, Your Lordship.
37 and 40, yes.
Then, Your Lordship, the next judgment is Sheila Sebastian versus R. Jawahar Raj, 2018 7
Just
SCC.
a minute, huh? Sheila Sebastian. Paragraph?
This is on forgery, Your Lordship, from paragraph number 19 onwards.
Okay.
In the earlier paragraphs, Your Lordship, the section has been described. So what has been laid down by the Honorable FX Court is that to constitute an offense of forgery, the vital ingredient of that offense is the making of a false document. So to convict somebody of an offense of forgery, what must be established that he is the person
Who has authored, who has
made that false document. He might be the beneficiary of that document, but unless it is established that he has the author of the document, then the
Mr. Pathak, itu agot bele agor hidnahan je korisilo tate thakibo. Mr. Pathak, on the point of forgery, also argues that the prosecution has failed to prove beyond reasonable doubt that the alleged prose document was authored / manufactured by the petitioners. And in absence of such evidence, the petitioner, not petitioner, appellants cannot be convicted for committing offense of forgery.
Support of that I have relied
In
on
support of such contention, Mr. Pathak relies on the decision of the Honorable Apex Court in Sheila Sebastian versus R. Jawahar Raj and others reported in 2018 7 SCC 581.
Paragraph number 17, 18.
Paragraph number 17,
18, 19,
17, 18, 19,
25, 26, 27.
25, 26, 27.
Further judgments, I'll quickly place it for your Lordship.
On the same point?
On different points, your Lordship.
Yes.
Firstly, your Lordship may have judgment of K. Purushottam versus State of Kerala, 2005-12 SCC 631. This is on the how a allegation of offense of section 120A criminal conspiracy is to be established.
Paragraph?
Paragraph 11, 12, 13, 14 and 15.
Yes.
I'll just read paragraph number 13 here, Lordship. That will be the most relevant paragraph. 13 and 14. To constitute a conspiracy, meeting of minds of two or more persons for doing an illegal act or an act by illegal means is the first and primary condition. And it is not necessary that all the conspirators must know each and every detail of the conspiracy. Neither is it necessary that every one of the conspirators takes active part in the commission of each and every conspiratorial acts. The agreement amongst the conspirators can be inferred by necessary implication. In most of the cases, the conspiracies are proved by the circumstantial evidence, as the conspiracy is seldom an open affair. The existence of conspiracy and its objects are usually deduced from the circumstances of the case and the conduct of the accused involved in the conspiracy. This is important, Lordship. While appreciating the evidence of the conspiracy, it is incumbent upon the court to keep in mind the well-known rule regarding circumstantial evidence that each and every incriminating circumstance must be clearly established by reliable evidence. And the circumstances proved must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn, and no other hypothesis against the guilt is possible. So, Lordship, here, once that element of forgery falls, then 120A and the resultant.
Arguing further, Mr. Pathak submits that when the allegation of forgery falls, the conviction under section 120B in the given facts of the present case shall also not be sustainable inasmuch as the conspiracy is required to be proved by circumstantial evidence, as there may not be any direct evidence of such conspiracy, which is also in the case in hand. However, there is no such chain of circumstances that has been brought by the prosecution to convict the accused, which leads to the irresistible conclusion of guilt of the accused person. And therefore, in the totality of the matter, according to Mr. Pathak, learned counsel, section 1, the appellant could not have been convicted under section 120B.
The other judgment is on 467, that is perhaps
No,
not
that is not.
necessary.
Yes, hello. Today?
What about the other appellant?
No, he's we will not even look into the how many pages written argument? How many pages? Huh? 70 pages written argument we will have not even touched. 2 pages maximum. For others it should be 1 page. For Purkasta it is extended to 2 pages. Not
By
done.
written argument, there is a small error. While listing the FIRs on the first page, FIR numbers 13, 14 and 15 are there. 16 and 17 are missed out, just on that list of
Okay, FR 15 and 16, na?
Lordship. 13, 14 and 14 and 15 are there.
FR number
16
RC 13, FR number RC 14,
RC
15 is there.
16 and 17, there are 2 more FIRs
16 and 17.
on the same date, same date,
Same section.
same section, same date, same section.
You want today?
Lordship, I'll cut it short only. His only stand is that there is no evidence to the effect that specimen handwriting was taken in presence of witness. Even though it was taken, no witness has been examined. That is his stand. My reply to that is that prior to 2005 amendment, there is no such law with regard to taking of specimen handwriting. Subsequently, after the amendment 2005, that section 311 has been incorporated. Prior to that, there was nothing. And police during investigation, Lordship, investigation is defined under section 2 of CRPC, Lordship. He investigated, he took the specimen, not only the specimen writing, but also the admitted writing and all, every evidence, every documents he has collected, and it was seized. And during trial, Lordship, witnesses were examined, basically PW6. He proved all the document that has been seized by the police, Lordship. And the specimen writing, everything was there itself, admitted writing also. So now they are saying that the expert opinion could not be relied upon as because specimen writing has not been proved, and therefore it should not be relied upon. So my lord, as because there was no law, your lordship sees the specimen writing. Though there are two witnesses there, though they were not examined, but the IO has been examined. He proved before the court that he took the specimen signature. Why shall we disbelieve the statement of the IO? There is no cross on their part that those specimen signatures are not there, lordship.
Okay.
Things there, lordship. Secondly, lordship, even for argument's sake, we remove the specimen signature. The opinion has been formed not only on the basis of specimen signature, but also with the admitted writings. Those admitted writings has been proved in the trial court, lordship. All the documents which contains the signature of the accused, those admitted signatures are there. They have not disputed that also. So why their argument that the expert opinion should not be relied, lordship? That is lordship. So my argument is very clear, lordship. The specimen writing can be relied upon on the basis of the fact that IO has been examined and they have not even put a suggestion to the effect that it is not the signature, lordship, not their signature, lordship. There is no denial to that effect that the signature appearing in all the forged documents are not there, lordship. So from that only, on that point of view, lordship.
Mr. Pathak, can you give a copy of your written argument to him?
I'll give it. I have a copy.
You give it to him, just point wise, you also give a note. We'll again record your argument on next day. Today it is only already 4. Huh? And if you want to add anything to the argument made by amicus, you are welcome to add. But don't repeat the same argument. Don't repeat the all argument. If you want to add something, you add, then we'll hear him. Okay.
Then finish, then I'll complete my
Okay.
entire.
When Purkast will be here? What talk to? Well, to pass this order right now. Will he be there? Because these two people are with Mr. Pathak, day after tomorrow you need not be present, but you just take note of his argument, what he argues. And if you can also prepare a note. So we are hearing on Wednesday, on Thursday, Mr. Purkasta, full stop. The amicus has concluded his argument, full stop. Fix this subject to his reply to the subject to his concluded, full stop. It is submitted that Mr. Purakasta, learned counsel for the appellant, shall address this court on Thursday, give the date, 5/9. Okay, accordingly, list this matter on 5/9 by slip. Possible?
Difficulty is that, lordship, every day 3-4 matters are coming hearing, lordship.
Where?
In High Court's matter.
No way out.
And all the voluminous, that is the difficulty. I'll have to come prepared.
Thursday. Let him do. You ask somebody to take note of the argument. If necessary, we'll adjourn again on that day. We'll complete on Purkasta, but no adjournment. Then we'll close it.
Thursday is 5th, no?
Hmm.
2 matters are already there.
Yes, we'll see. If then you ask somebody to be okay. That's all. Okay.